Okay, I'm going to repeat it for Lowry. If you cannot hear me, wave your hand.
Richard, how high? Richard.
We are all connected, is that correct?
I'll send them to them.
I believe so, yes.
Hey, Meg.
I'm up here.
Did my clerk point that out? Thank you.
I even made the angle over there.
And then you gotta get us with us, and then we're gonna get.
Judge Simon?
Yes.
Judge Montero?
Yes, good morning.
Good morning. Good morning. We are going to start a few minutes late simply because our Virginia City bus had some problems coming down the mountain.
This is spicy.
But we're going to get started in a few minutes, and I have every reason to believe that we are currently live. So we may be streaming live. So careful what you say during these preliminary comments.
Oh, can you?
No, come in here. Come on in. Come on, you'll be in the
Judge
camera.
Montero, you want to introduce us to your newest law clerk?
Yes, good. What? She can't quite reach the camera here.
We can see her.
This is Ms. Mayo. This is Ms. Mayo. She's been assisting our teen court for weeks now, getting them prepared. So, good morning, everybody.
Welcome to Law
from
Day.
Winnemucca. Yes. Can you hear us okay?
Yes, you could hear you. If you can be a little bit louder, that would be great.
Let's do this. Move it to the table here, and I'll turn. Let's see, I'm just not
Much
close.
better. If you've just moved closer to the mic, that is much better.
Well, see, we have it set up for the bench here, and then the podium is going to be separate. So I was kind of standing between the two. I'm a little closer to the microphone now.
That's perfect, Judge. Perfect.
Okay.
Let me give you a few background, or if you will, preliminary directions. We are going to call the cases. All the cases will be called from Carson City. Do I have a bench in Las Vegas? I am unable to see the bench in Las Vegas.
Oh, we're good. No, we're perfect. That's perfect.
Do I have a bench in Las Vegas? I am unable to see the bench in Las Vegas.
Am I seeing the Nevada flag?
Oh, it's back there. It's just blending in.
Las
Go ahead, no,
Vegas?
take a seat. Let's make sure we got it right here. You stay
Las
here.
Vegas?
Bryce, come take a seat too.
Hey, go. Get out of here.
For some reason, I'm not getting a response
see.
from Las Vegas.
The light is strong on Mason.
It's probably
It's because I'm white.
I
That's
can
all right.
now
The
see
flag's
all
okay
the
now.
benches. What I do not see are any judges on the bench in Las Vegas. Do I have students?
Testing audio
have-
from Las Vegas. Can you hear this, Jeff?
Hi, Brian. Brian, do you have Judge Sturman and Judge Denton anywhere?
Probably downstairs waiting for the elevator.
Hold that. I'll check.
And in the meantime, in your audience, do we have student judges from Canyon Springs and Liberty? Student judges from Canyon Springs and Liberty?
Judges meeting with judges in the conference room at Las Vegas. And then we have Liberty here. We're
Hi,
really
Michael.
attorneys
Good
from
morning.
Liberty. Good morning.
Michael, could you get your judges, both student and adult, on the benches so that we can make a few preliminary comments?
Sure, I'll go get them.
Thank you. Hi, Judge Simons.
Hello there.
Just by way of brief introductions, we are going to have, as I mentioned, the case will be called here in Las Vegas. We have the real, live and in-person Chief Justice of the Nevada Supreme Court, Mark Gibbons, is here with us. But what I'm going to do, for those of you who are in, oh, VC's here. Okay, cool. VC just arrived. In custody. Come on in, come on in. We have taken a step back in time. Virginia City is here in 1800s garb. I can't wait for you all to see them. Please take a seat. If you are a student judge from VC, would you please come to the bench? We're just waiting to get our judges in Las Vegas. Take a seat. Any of the available seats for judges? We've got here.
Yeah, good. How are you? Mr. Guy, when you talk, please try to use one of these mics, okay?
Sorry for the delay. We're still waiting for judges to take the bench in Las Vegas, and then we're going to ask them to leave again, so it's a little bit counterintuitive, but. Does it take us this long to get from the conference room to the bench? What was it?
Probably got locked out.
Good morning, judges in Las Vegas. We're going to do just take a few minutes of instruction for our judges in the two urban locations, if you will, in Carson City and the Regional Justice Center. Judge Simons and Judge Montero, along with your student judges, you can certainly do the same thing that I'm about to explain. Good morning, Judge Denton. Good morning, Judge Sturman. Thank you for being here with us. We have a full bench here in Carson City. We have benches in our other remote locations at Lowry High School and in Elko High School. And what we're going to do is have the cases called officially from the capital city here in Carson City. I'm going to ask all of the judges who are not robed currently, I'll have you leave the courtroom. In fact, all of the judges will leave their courtrooms, respective courtrooms, get robed up. We want students to be in robes as well. We have student robes available back in the robing areas of both Las Vegas and Carson City, so we're going to get everybody robed up. We'll go live in about 4 minutes, but I want, if you can, except for those of you, Judge Simon and Judge Montero, you may not want to leave your benches. I'm going to have the two courtrooms leave the benches, get robed. I will make introductory comments, and we will call the case just like we do in a regular appellate argument. We have a clerk in the courtroom. Owen Mooney is our court clerk for today. So everything is going to be done officially just like we do in a regular appellate argument. You are the year 5 of Law Day Live, so welcome. We have a full courtroom here in Carson City. I'm hoping that you all have full, or at least some interested people in your courtroom as well. Please be aware, we are live, meaning we stream live. We're going to be in as many classrooms as teachers allow throughout the state. We will be taking questions on Twitter. We will be taking questions and comments by and through our Facebook page. So in each of these locations, you are also being followed by an infinite number of other folks who may be interested in Law Day. Today is officially Law Day. It is May 1. This is being celebrated nationally. And I will make a few comments about that officially, but Law Day was created back in the 50s by then President Eisenhower when he decided that we should give, if you will, some inside look at what our judicial branch does. It is much easier to watch what your legislative branch and your executive branch does. It is not quite so easy to see how your judicial branch works. And so he created Law Day in order to open the doors of the courtroom and allow students and anyone who was interested in taking a look at what happens on the third branch of government. From my perspective, the most important branch of government, but I could be a bit biased. With that in mind, is there anyone who is supposed to be here at any of the remote locations that we are still waiting for? Okay, then we're a go. I am going to need each of the student judges, please, when they come back and take the bench as soon as the judge calls the case, if you would please announce yourself and say, I am Judge, your name, and where you are from. Okay? So with that, I'm going to ask that all of the judges leave the bench in their respective locations and get robed up, and we'll get going. This is pretty cool. We have just received, can you all hear me? I've now gone with the remote microphone. Can you all hear me? We have just received live a presidential proclamation declaring this Law Day USA 2014 from the President of the United States. It is a 6-paragraph proclamation, so I'm going to leave the first 5 paragraphs out, if you will, and instead give you the therefore clause of the proclamation, which reads, now therefore, I, Barack Obama, President of the United States of America, in accordance with the Public Law 87-20, as amended, do hereby proclaim May 1, 2014 as Law Day USA. I call upon all Americans to acknowledge the importance of our nation's legal and judicial systems with appropriate ceremonies and activities, and to display the flag of the United States in support of this national observance. So we're pretty special. We're part of a very important day, and the President of our fine country has declared that we should all give note to that day. I'm going to take a commercial break. Got my script. Everybody go. Michael, are you ready in Vegas?
When you are, just let us know. We'll bring our judges out.
One more time.
We ready
Yes,
in
Your Honor, we're
Elko
ready.
and Winnemucca? It is my pleasure to welcome you to Law Day 2014. It is my honor to again be able to host Law Day Live. Our program today will provide a rare opportunity for students to appear in the well of the Supreme Court of Nevada and argue real cases. We welcome everyone who is joining us both at our locations, but those of you who are joining us on the webcast and in your classrooms, please feel free to participate with us. You can comment on Twitter using the hashtag LawDayLive, or you can go to our Facebook page, which is titled Law Day Live. We are joining schools and organizations all across the country today in observance of Law Day. The theme for 2014 is American Democracy and the Rule of Law, why every vote matters. During the course of our program, students will argue 3 cases that were originally argued in the United States Supreme Court. The 3 cases that we will hear are Minor versus Happerstat, which is from the late 1800s, Oregon versus Mitchell, and Shelby County versus Holder, which was just argued in the United States Supreme Court in February of 2013. All 3 of these cases will and have affected voting rights in America. We will have student attorneys representing their clients from Virginia City High School, Lowry High School in Winnemucca. Feel free to cheer your school at this moment. Virginia City High School. Lowry High School in Winnemucca. Elko High School in Elko. Canyon Springs from North Las Vegas. DeMonte Ranch from Reno. And Liberty High School from Henderson. In addition to our students, we are joined by judges, again, statewide. Chief Justice Mark Gibbons will join us, Justice Michael Cherry, Judge Kevin Higgins. In the Regional Justice Center, Judge Gloria Sternum, Judge Mark Denton. In Winnemucca, Judge Mike Montero. And in Elko, Judge Mason Simons. So, in addition to our student attorneys, our student judges, I want you to all realize that not only will we argue cases today, but you will hear the actual deliberations that take place. Deliberations, as you may know, generally are done in private, behind closed doors. But in order to have a full and complete view of how the judicial branch works, how the legal system actually functions, your deliberations will take place on the benches with your student judges and the real judges in all of the locations. At this time, it is my honor to ask the clerk to please call the case, first case that will be heard, which is Minor versus Happerstat. Mr. Clerk.
All rise. Supreme Court of Nevada is now in session. Chief Justice Mark Gibbons presiding.
Good morning, everybody. Please be seated, and those of you in other locations outside Carson City, please be seated as well, and we will go ahead and proceed with our first case. Again, we begin with the case of Minor versus Happerstat, case from the year 1872. Virginia Minor, a woman, asked the United States Supreme Court to allow her to vote because she was a citizen of the United States and a citizen of the state of Missouri. Mrs. Minor argued that the state could not prevent her from voting because it did not specifically limit the right to vote only to males. Representing Virginia Minor is Liberty High School, and representing the state of Missouri is Virginia City High School. Our judges in the matter of Minor versus Happerstat are Judge Michael Montero from Winnemucca. And Judge Montero, if you could state the names of your student judges working with you in Winnemucca.
Yes, thank you. Good morning to everyone. And my student judges seated to my immediate left is Macy Paquette, and to her left, Bryson Prokaski will be our student judges for this first case.
Thank you very much. Again, we have student judges as well here in Carson City, which will be participating in another case, as well as the judges, and all judges are invited to ask questions to the attorneys as they present the case. So at this time, I'll turn the matter over to Justice Seda.
And if I may ask the appellant and the respondents to please take their positions at or near the podium. And by way of introductions, you may or may not be able to see this, but here in Carson City, we have actually taken a step back in time. The respondents, the state of Missouri, as well as a number of the other people who are here interested in this case in our courtroom, are dressed in period-appropriate outfits, including top hats. So it is a thrill to actually take this 1800 case truly back in time. With that in mind, are the appellants ready to proceed? Yes. That's Liberty. Are you guys ready to proceed?
Yes.
You want to be sure that you speak into the microphone. Our respondents, you may take a seat at council table, and the appellants can proceed. Oh, be mindful of the fact that you have time. I know that you have all planned and rehearsed for a certain period of time within which to make your arguments. We do have our clerk of the court here in Carson City actually using the Supreme Court timer, You will hear a buzz when you are down to 5 minutes, but please complete your thought at that time, and we will proceed with your argument as best we are able to completion. The appellants are ready to proceed. Please do so.
Okay.
Hello, I am Michael Antrolicchio, appearing on behalf of the appellant Virginia Minor, representing her as a person, a woman, and furthermore a citizen who is entitled to certain rights and privileges granted to all citizens of the United States, of this nation. On October 15, 1872, Reese Happersett, acting on behalf of the state of Missouri, violated Miss Minor's right to vote by not allowing her to add her name to the list of registered voters to vote in the federal election of 1872, therefore denying Miss Minor's right of her fundamental right to vote as a citizen of this nation based solely on the fact that she was a female. The law and the Constitution of the state of Missouri constrict the right to vote to every male citizen of the United States, and in doing so violates the United States Constitution by denying women who are citizens their right to vote. In 1790, people born within the jurisdiction of the United States were deemed United States citizens, and people who were born of two American parents who themselves were citizens were also deemed United States citizens. In 1855, Congress enacted a statute which had cited that a person born of an American father outside the jurisdiction of the United States were deemed United States citizens. Therefore, being that Minor, a woman born on 1824, a white female born of two American parents and born within the jurisdiction of the United States, is a United States citizen. The appellant acknowledges that Virginia Minor is a United States citizen on page 1, paragraph 2, quoting Miss Virginia Minor, who is a female, native-born citizen, and again on page 2, paragraph 2. The 14th Amendment certainly confirms Mrs. Minor's United States citizenship.
Judge Montero, I have a question from Las Vegas. May I address counsel, Judge Montero?
Pardon me?
I have a question
You may
in Las
proceed.
Vegas. Thank you.
Yes, you may.
Mr. Antrolicchio, where is the link between citizenship and the right to vote in the Constitution?
The right to vote and citizenship in the Constitution can be found in the 15th Amendment, where it states the right to vote by citizens, which acknowledges that the right to vote is a right by citizens.
Thank you.
Missouri abridged minors' fundamental rights by refusing to register to vote. On page 1, paragraph 3 in the respondent's brief, they had misquoted the 14th Amendment. They state, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall take or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. However, they had left off the very end of the 14th Amendment, which states, nor deny to any person within its jurisdiction the equal protection of the laws. It is this final bit that gives citizens of the United States the rights of citizens, regardless of gender, regardless of race. And the respondent we question whether they had left this out purposely in order to help their case, because maybe they were aware that this last bit of the 14th Amendment granted Miss Minor's right to vote and granted Miss Minor her citizenship. The next argument that we would like to present is the 15th Amendment. The 15th Amendment states, the right of citizens of the United States to vote shall not be denied or abridged by the United States or any state on account of race, color, or previous condition of servitude. It can be argued that women can even be defined as a group of people formally placed in previous condition of servitude. For example, they are often treated as property, meaning that their husbands dictate when they leave the house or what they need to do. They also have political dependence on their husbands in order to make decisions for them, including the right to vote. Women are also unable to attain property rights unless in very certain cases where a spouse is widowed. They also might be called citizens of the United States, but the fact of the matter is they are enslaved as African Americans were. The 15th Amendment, as I have stated before.
We have a question in Carson City.
Yes. Are you arguing that because a dowry is presented when a woman gets married, that they are being sold to their husbands?
Not specifically. We're stating that when they get married, they lose their rights. We're not speaking anything about the dowry. The dowry is to get the marriage. What we're speaking about is that she loses the right when she decides to have the marriage. And that, therefore, should not mean she loses the right.
Please continue.
The final issue I would like to bring up is the Supremacy Clause. We acknowledge that the respondent tries to justify their means, saying that Missouri had the right to make a law about voting because it is not stated in the Constitution. However, we argue that it is stated in the Constitution. In the 15th Amendment, as I have stated twice before now, it is stated that the rights of citizens of the United States to vote shall not be denied or abridged, which states that it is acknowledged by the 15th Amendment that the right of citizens to vote is the right to vote. The Supremacy Clause states, this Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. Although the 10th Amendment does state that states may make their own laws of issues that are not stated in the Constitution, the right of voting is stated in the Constitution, and therefore Missouri's laws on voting are therefore void and overridden by the Supremacy Clause. The right to vote is an integral part of being a United States citizen. The right to vote is a form of free speech which is protected by the First Amendment. One of the most important forms of free speech is voting for a representative in Congress, which speaks to their government on behalf of its constituents. The United States is not and could never be a true republic if female citizens are denied the right to choose their government representatives. Thus, the right to vote must be included in the rights of citizenship. Otherwise, U.S. citizenship is meaningless. And so, for this reason, Missouri violated minors' constitutional rights by denying her the right to register to vote, consequently showing that Missouri law violates the 14th and 15th Amendments and are therefore void. For these reasons and the reasons set forth in my brief, I ask that you declare any state law limiting the right to vote to males as void pursuant to the Supremacy Clause in Article 6, Section 2 of the U.S. Constitution. Do not allow this country to be only a country of men, and instead allow this country to be a nation of the people, by the people.
Thank you. A question from here at Lowry High School. I understand your argument that the 15th Amendment gives the right or limits the government from denying the right of a citizen to vote. And it does not, though, specifically give that right to females. Am I understanding your argument correct that you're equating conditions, those who have suffered under conditions of servitude, to apply to women?
Correct. Because although it does not state in the 15th Amendment gender, it does say the right of citizens to vote, not the right of males and nor the right of females. However, since we've previously stated that women are citizens of the United States and it is acknowledged by the respondent, we can only interpret that citizens means both males and females.
Recognizing that it does not specifically refer to gender in the 15th Amendment, correct?
Correct. And then it can be argued that women can be defined as a group formerly placed in previous condition of servitude. We believe that, yes, they were under harsh conditions and they were unable to attain property rights. And servitude means they're politically dependent on somebody else. And women were not granted the right to vote previous to this. So therefore, they were politically dependent on their husbands to make decisions for them. Therefore, they must have been in a position of servitude.
Even more, you cannot deny that a huge portion of the population be denied the right to vote, as you cannot say we are a republic without having the full republic of the people voting.
One further question from.
Go ahead, Judge Montero.
One further question here from Lowry, and then I may turn to my colleagues. And the question is as follows. Do you believe that this is an issue that the Supreme Court should be deciding on the issue of women's suffrage, or is this an issue that you feel would be best left to Congress?
This is an issue that the Supreme Court must take. As we previously stated, women are such a huge part of the population, we cannot deny them the right to vote. And within the Supremacy Clause, within the Supremacy Clause, they state that the states cannot deny citizens the privilege of the citizens. So that means we cannot deny women the right to vote. And
Thank
the
you.
Supremacy Clause can, okay, you can read that if you want.
Are there further questions?
Recognizing that we live in a federal system where this court recognizes the sovereignty of the states, wouldn't it be more appropriate, if you're asking us to make this change, that this court rule that women are allowed to vote in federal elections, but it's up to each individual state to decide whether they're allowed to vote in state and local elections?
Correct. We believe, however,
you agree
that,
with me? Okay.
well, we believe that the states are not able, actually, to create legislation that overrules the Supreme Court, as stated in the Supremacy Clause. Therefore, in federal elections, citizens may vote, but in state elections, women should also be granted the right to vote.
Well, perhaps you misunderstood my question. My question is, should this court say that women have the right to vote in federal, national elections, then it's up to the separate state sovereigns, each state we recognize as a separate sovereign government, that they decide in their elections and make their own rules in each state?
No, we are not stating that. We are saying that women should have the right to vote in federal and state elections, as they are choosing who represents them in government.
We apologize, Your Honor.
We have another question here from Lowry, if we may.
Given the fact that at this time married women are considered property, who's to say that if given the right to vote, women wouldn't just side with their husbands and in turn a second vote for the husbands?
We would state that having a second vote with their husbands, women should all be able to form their own opinions. They shouldn't have to go to their husbands in order to get their suffrage. They should be able to choose their suffrage and choose for who to vote instead of having to rely on someone else for them to vote.
Question? And another question from Lowry, if I may. Adding on to my colleague Justice Paquette's question, I'd like to ask, should we, the Supreme Court, rule in favor of Ms. Minor, who is to say that women, in fact, even exercise their newly granted rights to vote?
What says that men have to exercise their right to vote? It's just the fact that women should be allowed to have this privilege and right.
Do you feel that women may be, they feel threatened by men in the voting lines? They wouldn't in any way, once again, as Justice Paquette said, feel threatened and side with their husbands because maybe they don't know any better?
No, because In New Jersey, women were also granted the right to vote. And women exercised their right to vote in New Jersey until it was overruled by their court and finally was taken off. And yeah.
Thank you very much. Are there any other questions of our attorneys, or if not, we'll move to the respondent for argument.
No.
Thank you.
Thank you, Your Honor.
Thank you.
The respondents may take the bench or the podium here in Carson City. You are ready to proceed.
Thank you. Justices, my name is Stephen Puntard. I am here today to argue on the behalf of Mr. Reese Happersett in the state of Missouri. We do concede that Mrs. Minor is a citizen of the United States under the 14th Amendment, which says any person born or naturalized within is as such. But in the second section of the 14th Amendment, it states only that states that do not allow men over the age of 21 years the right to vote will be punished. Never does it say that women are not allowed to vote. And this should be left up to the states underneath the 10th Amendment. The 10th Amendment says power is not delegated to the states nor prohibited by it to the states or reserved to the states. Now, if states such as Missouri were to decide that they would like to have women the right to vote, they may do so underneath the 10th Amendment.
May I ask a question, Judge Montero?
Please.
Counsel, I understand your argument, it should be left up to the states, but aren't all American citizens entitled to equal protection under the 14th Amendment of the United States Constitution? And since you concede that women are citizens of the United States and aren't all citizens and other persons as well, residents here, entitled to equal protection, and as such, shouldn't women have the right to vote in all elections, state or federal?
No, sir.
Okay, and how come?
Yes, they are allowed equal protection underneath the 14th Amendment, which is clearly stated within the 14th Amendment. But never does in the 14th Amendment say that voting is a privilege to women. It is not a necessary privilege to women.
Great, thank you.
You may continue.
So until there is anything within the Constitution that would expressly give women this right, there's nothing that can be changed. So Missouri and Mr. Happersett are correct in denying Mrs. Minor her right to vote, or her...
Montero, I have a question from Las Vegas for counsel, please.
You may proceed.
Counsel, if we leave this decision to the states, wouldn't that lead to an unbalance of power? Certain states may choose to give the right of suffrage to women and thus have more votes in a popular election, such as an election for president, giving them an unfair advantage in the vote. How can we leave this to the states?
We can leave this to the states because in the Constitution, that is a right that is given to the states, and it's the state's choice, which should be respected by the nation.
Question here from Lowry. You're under this argument, you would or would you agree that women are subject to the laws of the states and the federal government?
Yes, they are subject to the laws of the state and federal government.
And as citizens, your argument is that although they're subject to the laws of this land, they're not allowed the ability to vote and have a voice in the creation or formation of those laws. Would that be correct?
That's not quite what I'm saying, sir. I am saying that they are subject to the laws stated by the federal and state governments, but a part of those laws, it never says that women are specifically given that right. And so since it is not specifically put in there, then it is left up to the states by the 10th Amendment.
Question from Carson City and disclosure. Judge Montero?
Please proceed.
First of all, my disclosure is that I was born and raised in Missouri, but I can still be fair. Secondly, even though I'm the oldest one on the Supreme Court, I did not dress like that when I went to high school. We needed a little levity here.
Good.
What I want to do is get you to say, in other words, what you're saying is aside from the 14th and 15th Amendments to the United States Constitution, the only way that nationwide women can vote is to amend the Constitution of the United States.
Yes, Your Honor.
And do you know the process of amending the Constitution of the United States?
No, Your Honor.
Thank you.
Now, talking about the 14th and 15th Amendment, I would like to state that since it wasn't expressly put in there, that it may have been specifically intended for it not to be in there. That they specifically made it so that gender was not stated because they did not intend for it to expand to women as well. But once again, leaving it up to the states.
So just to clarify, you're saying that the writers of the Constitution left out women on purpose?
Yes, I am. And if the 14th Amendment had made suffrage an absolute right of citizenship, then why would the 15th Amendment be needed to clarify? In the 13th Amendment, it talks about previous conditions of involuntary servitude. This is what we believe the 15th Amendment is speaking about, involuntary servitude. And in the 15th, like the appellant had said, that it should not be denied by race, color, or previous forms of servitude. This is what we believe it refers to, and that marriage is not a previous form of servitude because it is voluntary.
Yes.
Judge Montero?
Yes, you may proceed.
Sir, counsel, are you arguing that because the federal Constitution is silent, that the state has an inherent right to discriminate against its own citizens?
Yes.
Thank you.
We also have a question that has been brought to our attention that comes from Twitter. And the question reads as follows: should states have their own laws concerning whom should vote?
Yes, they should, and they already do. Certain states require people to be a certain age.
Question from Las Vegas. I had a question on something you mentioned previously about how that only they can make laws on race and previous forms of servitude, but what makes it so they can't? Doesn't it apply to gender too? Shouldn't we not because women are defined as citizens, and you have stated that, shouldn't they still be allowed to vote because they are citizens, and we can interpret that citizens expands regardless of gender?
No, because it was specifically not put in there to specify gender. So therefore, we believe that it was not intended to expand to gender, to females.
Your Justices, if I may introduce myself. My name is Megan Wheeler, and I am his co-counsel, and I would also like to answer this question, if I may.
Please proceed.
Nowhere in the Constitution does it say women can't vote, and nowhere in the Constitution does it say women can vote. So that decision is left up to the states, as my co-counsel has stated several times. And we are not asking you to change that law right now in this courtroom. We're asking that you leave that decision up to the legislature of the states, including Missouri.
Thank you. You may continue. Is there further argument?
Yes, there is, Your Honor.
Please proceed.
After all that we have said, it is our position that the 14th Amendment confirms Mrs. Minor's U.S. citizenship, and it protects her privileges and immunities as a citizen. However, voting is not provided as one of these necessary privileges or immunities listed in the Constitution. The 15th Amendment backs the principles within the 14th Amendment and states that race cannot disqualify one from voting. It specifically leaves out any mention of extending suffrage to women. The 10th Amendment allows states to decide any issue that is not spelled out in the Constitution. Since women's suffrage is not stated in the Constitution, the state of Missouri was acting within its legal rights.
Counsel, I have a question. So if we leave everything up to the states, are you saying some states could say you can only vote in Kentucky if you were born in Kentucky, and some of our newer states in the West, like Nevada perchance, if they wanted to lower the voting age to 18, even though everybody knows you have to be 21 to make those kind of decisions, those states would be free to do that?
Once again, yes, because it is not specifically stated within the Constitution that they cannot. They may, with underneath the protection of the 10th.
Your Justice, Rhode Island, Virginia, and Louisiana still are the three last states that require property, to own property to be able to vote, and I don't see anybody having a problem with that right now. But if that were to be an issue, then they could bring that up to their state legislature and try to get that fixed. Texas and Wyoming both have free and equal exercise, so women are allowed to vote in the Wyoming territory and the state of Texas. So that is their prerogative to allow women to vote. So why is it not Missouri's prerogative to allow women not to vote?
Thus, we urge the court to find that Missouri's law is constitutional and the states have the right to determine voter qualifications as they see fit.
Thank you. Are there further questions from any of the justices? I think we have a question from here at Lowry.
Should the right to vote be considered one of the fundamental privileges of citizenship?
No, it is not provided by the 14th to women. It is to males 21 years of age or older within Section 2 of the 14th Amendment. But it says nothing about women's voting privileges.
We do not believe voting is a necessary privilege at this time.
Thank you very much. In order to, I think, stay on track with our time today, I believe at this time, thank you to counsel. I don't know if there was some time reserved by the appellant for rebuttal. Not being in the same courtroom, I don't know if that was done. Justice Seda, could you
Judge
answer that
Montero,
question?
We have decided to proceed with general questions as opposed to the right of rebuttal in order to give the students, both students here in the courtrooms as well as the student judges, an opportunity to participate before we ask our judges to deliberate. As you may recall, Judge, you will be doing your deliberations live, which means we want to hear the decision how you reach the decision that you're going to announce here today. Moreover, I want to remind everyone that although this case has long since been decided by the United States Supreme Court, none of our judges here today are bound by that decision. If in fact you feel that the decision should go the opposite way, your deliberations will lead you to what you obviously believe will be the right decision. With that in mind, there will be no rebuttal. If we have any further questions, we'll take those, and if not, then we'll move immediately into your deliberative process. Judge, if you would call for questions from your school or from your court, and then we will call for questions anywhere else.
Any further questions here at Lowry? I think we're okay. Any further questions from Las Vegas, Carson City, or Elko?
No.
Hearing none, we will then proceed with deliberations. And I think it would be important at this time, as we here at Lowry begin our deliberations, to provide both our viewing and our live audience to have just a little bit better understanding of the historical context of this case. As justices, we felt that would be important, as we know we have about maybe 200 students here in the auditorium at Lowry, and we want to be able to get out of here unscathed once this is over. With that being said, this case was decided by the United States Supreme Court in 1875. If you will recall from your history lessons, that was just roughly 10 years after the Civil War ended. This would have been approximately 7 years after the 14th Amendment was adopted, and approximately 5 years after the 15th Amendment. The 14th Amendment, if you will recall, provides citizens' rights and equal protections under the law, and the 15th Amendment prohibits federal and state governments from denying a citizen the right to vote based on that citizen's race, color, or previous condition of servitude. This is a case that was decided at a time when the entire Supreme Court was made up of males. A little ironic that we have a female on our panel today. It was 106 years later before the first United States Supreme Court justice was a female. Ulysses S. Grant was in the White House at the time that this case was decided, and in fact, that was the presidential election to which Ms. Minor registered to vote in 1872, approximately 3 years before this decision was rendered by the United States Supreme Court. So with that background, realizing that we are discussing and deliberating this case in 1875, we'll now begin the deliberations, and I turn to my associate justices of the Supreme Court today. And this is our opportunity to talk about the arguments that we've heard, the briefs that we have read and prepared by the attorneys, and to deliberate at this point whether to affirm the Missouri Supreme Court's decision which prevented Ms. Minor's right to register to vote, or to overrule the Missouri Supreme Court decision which would in effect allow Ms. Minor the right to register to vote. And to begin that discussion, I think that as we've heard from the arguments, the arguments really center around these very new amendments to the Constitution, the 14th and 15th Amendments to our United States Constitution. And to begin that argument, and as we heard from the discussion, you know, there is no argument that Ms. Minor was a citizen. And I feel like the discussion today is whether a citizen has the right to vote under our current Constitution. Justices, thoughts?
Although the Constitution does not say that citizens don't have the right to vote, Missouri is completely in the right with the 10th Amendment, which gives this power to the states. And as they've mentioned before, the word woman is never once in the Constitution. And the framers obviously meant it that way.
How can we not, though, consider that citizen does not apply equally to both genders? This 14th Amendment gives protections to the citizens, and the 15th Amendment gives citizens the right to vote. Although it does not specifically refer to gender, I question whether the framers in Congress intended that citizen would include both males and females. Any thoughts?
As I've said before, obviously there's no question that Miss Minor is not a citizen. It's simply that Missouri has the right to exclude or include whoever they feel fit to vote.
And at this point, the law in Missouri only allows males, I believe over the age of 21, the right to vote.
I believe so.
I'd also like
Justice
to point
Paquette.
out.
Yes.
I'd also like to point out that the 14th Amendment gives citizens the protection under law, and the law at this time, from the Constitution and the states, is that the states may make their own decisions regarding women, and they followed that law. So really, we're talking about changing the Constitution. And do we have the right to do that?
Changing the Constitution. Doesn't the 15th Amendment give all citizens the right to vote? Are we changing the Constitution by considering a woman to be a citizen?
It's more pointing out that women was once again never mentioned. So we don't really
never
know.
Specifically.
We don't really know what the framers were thinking at that point, and if women was indeed what they were, something that they thought was important.
Well, it brings up a good point. Should we, as a Supreme Court, be deciding this issue? Or is this a matter that would be best left to Congress to make this decision? Should this be an issue that should be left to the legislative branch rather than to the judicial branch? For purposes of deliberation, any thoughts?
I do believe the legislative branch should at least play a role in deciding something that's so integral to, as they said, our democratic society that our great nation's been built upon.
I do find it interesting, I'll have to say, that when these amendments to the Constitution were adopted, drafted, argued and adopted, that it did not specifically enumerate these rights to women. That is interesting.
That is interesting.
Yeah.
Well, Justice Montero,
Yes.
Isn't men just what the collective pronoun was used back with the framers? That since we don't have a gender-neutral collective pronoun to use in English, that men includes everybody, all men are created equal. I don't think they meant all males are created equal. I think they meant everybody.
But the interesting part about the 15th Amendment is it doesn't refer to specifically males, it refers to citizens. And both sides have argued today there is no dispute that Ms. Minor is a citizen of this United States of America. Although I would concur with my colleague who does refer to the male pronoun as being typically used. I would like at this time, yes, please proceed.
Justice Paquette, I was wondering, as in the unique position that you sit here today in the 1800s, if you can't be a voice for the right to vote. How do you feel about that, Justice?
Well, I feel as though I would like I myself would like to vote, but I'm looking at the facts and reading the passages in the Constitution. I am siding towards only men voting. I understand from what I have been reading. I feel like the facts are more supported on that side of the argument.
So if we were, as a collective panel here at Lowry High School today, to have to decide this case, I think Ms. Paquette has maybe indicated her position, but before we go there, specifically, let's turn to Justice Prokaski. How would you vote?
I would vote to affirm the state of Missouri on the simple grounds that they are not preempting any sort of the Constitution under or given the rights that the 10th Amendment has provided for the states.
I would tend to disagree with my colleague on the Supreme Court and overrule the Missouri Supreme Court's decision on the basis that the 14th Amendment addresses citizenship rights and equal protection under the laws to all citizens. That then read in conjunction with the 15th Amendment, which prohibits federal and state governments, such as the state of Missouri, from denying a citizen the right to vote based on citizenship. And for that reason, I would vote to overrule the Missouri Supreme Court's decision. So, Justice Paquette, you are in the unenviable position of having to break the tie today between your colleagues on the Supreme Court and decide the case.
Again, nowhere does it say women can vote, but it also doesn't say women can't vote. It does talk about citizens. And I know that I myself and I know other women would like to vote, so I would say I would like to overrule the Missouri Supreme Court's decision, which would allow Ms. Minor the right to register and vote.
So I think we have, Justice Seda, a decision today, a 2-3 decision to overrule the Missouri Supreme Court, which would allow Mrs. Minor the right to register. And that is the decision of the court here today. Thank you all very much. I would like to add as another historical fact to this, that it was actually the 19th Amendment to the United States Constitution which ultimately allowed this right to vote based on gender. And that 19th Amendment was passed in 1920, which was approximately 45 years after the decision in this case was handed down by the United States Supreme Court. Thank you all very much. Justice Seda, back to you.
Thank you, Justices at the Lowry Courthouse, Lowry High School Courthouse, to our participants here in Carson City, to our participants in Las Vegas. I am always so honored to be a part of this, and primarily because of the commitment and the professionalism. The manner in which you present these arguments is in no way any different than I believe the arguments would have been made back in the 1800s, and you should all be very proud of the arguments you made here today. As a point of reference, notwithstanding history and that it took until 1920 before women actually had the right to vote, for our two females who were compelled to either argue or make a decision that may have gone against their gender interest, I want you both to note that you did exactly what an advocate and what a jurist should do, and that is you took law and applied it to facts, and you rendered a fair and impartial decision, and on behalf of the state, Ms. Wheeler, you argued on behalf of your client the way you should have, and for that you can be commended. And I'm sorry, the student attorneys from Liberty, I cannot see you because we have our cameras are focused on our bench in Las Vegas. To both of you, you obviously persuaded the court to go a different way. Congratulations, a job extremely well done. And we will move into our next argument. The parties in both courtrooms who have previously argued may be seated. And we'll move into our next argument, Again, a voting rights case originating out of the 1965 Voting Rights Act, where the United States Congress enacted the act purported to prohibit any discrimination in voting. In 1970, the United States Congress made several key changes to the 1965 Voting Rights Act. Among other things, the revised act lowered the minimum voting age from 21 to 18 and required the states to apply this new lower voting age to all state and federal elections. The next case that we have before us, Chief Justice, if you would call the case of Oregon versus Mitchell.
Yes, thank you, Justice Sada. Our next case is the case of Oregon versus Mitchell. And as Justice Sada stated, the court considered whether the Congress exceeded the powers granted to it by the United States Constitution. In addition, the court will also consider if the Congress intruded on the powers of the states by requiring states to allow otherwise eligible voters aged 18 and older to vote in both state and federal elections. Representing the state of Oregon are students from Damonte Ranch High School in Reno, and representing Attorney General John Mitchell are students from Lowry High School in Winnemucca. Justice Sada?
Chief, we have to add one chair to the bench at this time. We have another student judge who needs to both be robed and join us. We'll quickly bring a chair up while he's being robed. Just give us one moment before we begin. We frequently, in the Supreme Court, when we are hearing arguments, have to reconfigure the bench. This is not at all unusual. Some justices can and frequently are disqualified from hearing cases, and so they come and go on the bench. This is not at all unusual to bring another member. Our newest judge has now joined us. Sir? Chief, with your permission, I would ask our new judge to please introduce himself.
Hello, good morning. I'm Brandon McQueen from Damonte Ranch.
Thank you, Justice. Justice Gibbons, if you would ask the parties to proceed.
Yes, and also, just I believe we have Justices Mark Denton and Gloria Sturman in Las Vegas. They're joined by judges from Canyon Springs High School in North Las Vegas and in North Las Vegas as well. So, counsel, would you introduce yourself, please, and you may proceed with your argument.
Chief Justice Gibbons and the Justices of the Nevada Supreme Court. May it please the Court. My name is Isabella Dominguez, and alongside with my co-counsel Allison Marshall, we represent the state of Oregon. This case discusses states' rights and the federal government's unconstitutional mandate that has forced the state of Oregon to change its voting laws. Before the Court today are three issues. First, the lowering of the voting age. Second, the banning of residency requirements. And lastly, the outlawing of literacy tests.
In regards to the voting age, Oregon has maintained consistency with the minimum age being 21. The amendments to the Voting Rights Act of 1965 mandate that all states lower the voting age to 18, an unconstitutional act by Congress that violates Oregon state sovereignty to control their state elections. The respondent has acknowledged that laws regulating the exercise of constitutional freedoms are appropriate. For example, they state that 18-year-olds are prohibited from purchasing and possessing certain firearms, a right guaranteed by the Second Amendment. This logic affirms the respondent agrees that certain situations require a more strict definition of responsible adulthood, such as voting for elected officials that will govern society. The argument the respondent makes that an 18-year-old can enter into a binding contract does not correlate with voter readiness. The state of Oregon has held the minimum voting age at 21 with the belief that maturity and life experience are gained between the years 18 and 21, allowing this demographic of citizens a chance to better develop judgment regarding the election process. Studies consistently show that the frontal cortex, which is an area of the brain responsible for higher order thinking, is not fully developed at the age of 18. Oregon's voting laws are allowing more time for maturing and cognitive development to ensure a capable voter pool.
I have a question from Carson City. You're talking about development of the brain. Now, aren't these the same people that we send over to Vietnam to defend our country? The 18-year-olds, 19-year-olds, 20-year-olds? Don't you think they should have the right to vote if they're going to die for our country?
Absolutely, and Congress has the power to change military voting ages. We know that once citizens under 21, but maybe 18, 19, 20, who go to war do have the right to vote. There is an exception to our rules
And where is that found?
in the Constitution.
Go ahead.
Thank you.
Are you arguing that Oregon and any other state should have the option of establishing a voting age, and in doing so, wouldn't this create an imbalance in power between the states? Certain states may choose to allow voting at 18, others at 21. This creates an imbalance because the states that allow voting at 18 have more people voting for president, gives them more power in an election, and isn't this inherently unconstitutional under the 14th Amendment?
We are arguing that states do have the power to choose 18 or 21 or whatever age for their elections, and that is because states know their people, they know what is best for their citizens and what they want.
Okay, but my question is not about what the familiarity with Oregon with its voters. My question is, doesn't it give
You lose the sound?
Judge Sturman, we may have to have a repeat of your question. It appears as if we lost audio for a moment. Would you restate your question?
Right. Yeah, my question is not about Oregon, about power under the 10th Amendment. My question is about creating an imbalance between the states. If you allow certain states to only vote, to control their voters, only being able to vote at 21, while other states decide to vote at 18, this makes the states that have more voters have more say in an election. It gives them an unfair advantage over states that only allow voting at the age of 21. Wouldn't that mean that this should be something that's decided not under the 10th Amendment as something left to the states, but should be decided for the nation as a whole by our Congress?
The fact of the matter is that this is supposed to be left up to the states and it's not a congressional mandate, because under the 10th Amendment, the states have the right to make their own voting laws, and Congress is overstepping its boundaries by trying to limit the power of the states.
I have a question. In talking about brain development and age, is what you're saying is that we're in effect sending children off to Vietnam, off to war?
That is not what we're suggesting at all. We have to look at studies to show trends, and that's what we're looking at for voting. We know that there are some people whose brains develop earlier, and those are the people that are signing up to go overseas because they believe they're ready to serve the country.
Well, they're not necessarily signing up, they're being drafted. Right?
And we do. Maybe continue?
Yes.
And we do believe that when those people are drafted, they go away from their houses and they have to mature quicker, and they are put in different situations that require them to do so.
Okay, question from Vegas. So if we're sending them to war so they can develop quicker, does that mean that we're going to have everyone who goes to war, no matter what age, be allowed to vote?
We've already mentioned that people who do go to war under the age of 21 do have an exception to vote.
All right.
Question in Elko. Does that exception apply to state elections as well, or is that only for voting in a federal election?
The exception is only in federal elections as the law is right now.
So you've suggested that the solution is allowing these military service people to vote, but isn't that sort of somewhat disingenuous? the fact that they're not able to actually vote for their state representatives and various state office holders. Is that somewhat disingenuous to suggest that's the answer?
Can we have that question repeated, please?
What I'm asking is, isn't it somewhat disingenuous if they can only vote in a federal election and they're not able to vote in their own state elections where they would elect their state office holders, the various state representatives that might advocate for them back in their home state? Isn't it somewhat ridiculous to say that's the solution here, that they can just give the right to vote to service members, and that would only apply to federal elections? Doesn't it sort of defeat the purpose?
It does not defeat the purpose. National elections oftentimes do presidencies, which is the commander-in-chief, the person in charge, and states, what we are saying is, do have the ability to choose their voting age and determine what's right for their citizens.
A question from Las Vegas. Since most states impose criminal sanctions on those under the age of over the age of 18, allow marriage without parental consent over the age of at the age of 18, and allow contracting at the age of 18. Why is voting different from all these other responsibilities and privileges of citizenship? Why should it be treated any differently?
Well, one thing we believe is that when you enter a marriage or a contract, oftentimes you're just dealing with yourself and maybe one other individual, but voting has the ability to affect thousands across your state and the nation.
You maybe proceed.
Okay. This congressional mandate is unconstitutional by Article 1, Section 4. Congress passed these amendments by misinterpreting the manner of elections. Expanding the word manner to include voting age is an unreasonable occurrence validated by our nation's founding fathers in Federalist Paper number 60, which states that the qualifications of potential voters and candidates are not to be altered by the national legislature. National and state laws which restrict Second Amendment rights, brain research that supports maturing at a later age, and Federalist 60 articulating the intention of Article 1, Section 4, all support the repeal of these unconstitutional mandates forced upon Oregon.
Oregon implements residency requirements to maintain the integrity of the voting process. The respondent has brought up the issue of voter fraud, which will ultimately be reduced by enforced residency requirements. Their incorrect interpretation of the Civil Rights Act of 1866 as establishing gender equality in voting demonstrates a lack of understanding regarding suffrage. The act did not grant gender equality. The issue of gender was not resolved until the 19th Amendment in 1919. The respondent's interpretation of the 14th Amendment is that it helps, quote, newly freed slaves vote without the fear of exclusion caused by a residency requirement, end quote. This amendment does not revolve around the issue of residency requirements but rather the 14th Amendment defines what a citizen is. Residency requirements are constitutional. The Constitution does not specifically discuss using residency requirements, intentionally leaving it up to the states under the 10th Amendment to determine voter eligibility. Using residency requirements prevents a voter from crossing state lines and voting illegally, which maintains the integrity and the sanctity of the American voting system. A citizen cannot vote in a state or county in which they do not reside. The decision whether or not to have residency requirements is not a federal government choice, but rather a state's, due to this power not being granted to them in the Constitution.
I don't know if you can hear me, but you just referred to the American voting system. Isn't that what we're talking about here? The American voting system? In other words, it goes across the land, not just by state?
Yes, but the American voting system also includes the states, as the states are a part of the American voting system.
All right.
The decision whether or not to have residency requirements is not a federal government choice, but a state's, rather due to this power not being granted in the Constitution. States demand residency requirements to ensure that those voting in their states are actual residents. Only those who are directly affected by the vote can vote.
President George Washington mentioned in the first State of the Union address that knowledge is critical, quote, to the security of a free constitution it contributes in various ways by convincing those who are entrusted with the public administration that every valuable end of government is best answered by the enlightened confidence of the people, end quote. In addition to President Washington, the state of Oregon believes that having a competent pool of voters is a key element to successful democracy. Knowledge allows individuals to form sound decisions regarding the election of their leaders. Knowledge coupled with the maturity gained between 18 and 21 ensure veracity of elections. Because of this, we advocate for literacy testing and educated citizens who understand the voting process, who they're voting for, and why they're voting. Similarly to residency requirements.
Question from Las Vegas. Council, may I ask a question from Las Vegas? Isn't literacy just a thinly veiled attempt to exclude those that we don't want having a role in our government?
Absolutely not. Literacy testing is to ensure a competent pool of voters who understand what they are doing and the potential effects.
But again, isn't it just a way that those in power may seek to exclude those who may wish to remove them from power?
Again, that's absolutely not the intention of literacy testing.
I think it was. Thank you.
Okay. Similarly to residency requirements, literacy testing is the state's issue by the 10th Amendment. The respondents mentioned a potentially problematic situation stemming from differences in educational quality of various institutions. Different schools across the nation are essentially teaching the same information. In addition, students who are not satisfied with the education provided have access to many free resources to further themselves, such as public libraries. Furthermore, the literacy test is not demanding a doctorate degree in government and politics to determine eligibility. It is simply intended to secure a minimum standard needed to protect democracy. For these reasons, we ask that the court rule on behalf of Oregon as state rights have been intruded upon.
Are there any other questions for council from the judges here in Las Vegas or other locations? We have no questions in Las Vegas. If there are any questions in any of our other locations. Hearing no questions, Justice State, I believe that we're ready for the next argument.
Very well. The respondent, on behalf of John Mitchell, the Attorney General from Lowry High School.
I, Ms. Gilboy, will be arguing the voting age and why it needs to be lowered, and my co-counsel, Madison Mayo, will be arguing the residency requirements and literacy tests. The position taken by the appellants is wrong. The appellant would have you rely on the 10th Amendment as the definitive factor in this case. This completely neglects to take into consideration Article 1, Section 4, and the 14th Amendment of the United States Constitution. Contained within these is the authority given to Congress to mandate a lower voting age in all elections, be them local, state, or federal. The appellant directs this honorable court to the Federalist Number 60. While this is an interesting historical sidebar, it is not an established case law, nor is it precedent.
Question from Carson City. Ms. Gilboy? If what you're saying is correct, then why did we need to amend the Constitution to allow women to vote? Why don't we need to amend the Constitution to allow the voting age to be reduced to 18 throughout the country?
Because without a consistent voting age across the nation, this will bring rise to voter fraud and many other issues.
Could you expand on that answer about the voter fraud?
Yes. I have it with the voter fraud. If you have an 18-year-old in a state who cannot vote, and then there's a 21 line, that individual will be forced to use voter fraud techniques, including fake ID, and jump the lines in order to vote for something that they feel they need to.
Question from Carson City. Isn't that why we implemented the literacy test and residency requirements to stop those?
Yes, but that does not have anything to do with lowering the voting age. The appellant argues the 10th Amendment grants the rights to states to set their own voting age, to establish residency requirements, and to conduct literacy tests. This position is inconsistent with Article 1, Section 4. Under this article, when combined with the 14th Amendment, authorizes Congress to set requirements for voting, be it a local, state, or federal election. Under the 14th Amendment, no state shall...
Question from Las Vegas. Doesn't Article 1, Section 4 only apply to time, manner, and place of elections, not who is actually voting?
Voting age is a manner.
Okay.
These privileges or immunities consist of life, liberty, and property, as well as voting. According to Article 1, Section 4, Congress may, at any time, by law, make or alter such regulations involving times, places, and manners of holding elections for senators and representatives. Article 1, Section 4 infers that the framers of the Constitution intended for Congress to do what's best for this nation. The Equal Protection Clause concludes that states must apply law equally and may not discriminate people or groups of people arbitrarily. This clause and the 14th Amendment do not render the states powerless to set voter qualifications for their own local officials and agents.
We have a question
but they-
in Las
I have
Vegas.
a question from Las Vegas. I mean, isn't our whole system a federal system? Isn't the whole concept that we have, in effect, 50 sovereign states, and that's what the 10th Amendment recognizes, that the states are their own laboratories, that they have the right to develop their own systems for state elections?
Yes, but if the states have different voting ages, and as I will later talk about with the qualifications requisite, if those states have different voting ages, then not everyone from all of the states will be allowed to vote. So we need to have a consistent age so every single person has a chance to vote.
Question from Las Vegas, and wouldn't that just apply to federal elections, not state and local?
Yes, we're not saying that the state needs to change all of how it does the voting, but we do need to have a consistent voting age. So again, we will eliminate voting fraud and everything that comes along with that issue.
Counsel, again, a question from Las Vegas. I don't necessarily disagree with you, but shouldn't this be left to the states? Just as the states chose whether they should allow persons at the age of 18 to marry, to enter into contracts, to be held liable for crimes, shouldn't we leave it to the states to make that choice? I mean, eventually all states got to that age, but it was left to the states to get there on their own. And wouldn't this more appropriately be left to the states to move in this direction should they choose to do so or not?
No. The states do talk about how you stated how they have marriage rights and firearms and everything, but that doesn't necessarily, it does in a way affect the nation as a whole, but we are, by saying that states have a say in who and what the voting ages are, that is affecting our nation as a whole because the states and all of the people are choosing who's going to be president, who's going to be representative. And if the states aren't all consistent on this, the choices that we make aren't going to be consistent.
Counsel, it's interesting you mention it affects how president's selected. Isn't the real reason behind this change is because members of the Democratic Congress want to increase the number of presumably Democratic voters to ensure that President Nixon doesn't get reelected in 1972? Isn't that the real reason you're seeking to change this?
We are not stating that we want to lower the Democrats' age level. We're stating that we want to lower all of the citizens.
Well, everybody knows young people today are young liberals, not with the values of the president. So the assumption is that the more 18 to 21-year-old voters, the likelihood is that who knows could be elected president rather than President Nixon.
Yes, but isn't it fair that the 18-year-olds all have a say?
As well as in state elections?
So you admit this is just a guise to change the presidency?
No. The 15th Amendment mandates that the rights of citizens of the United States to vote shall not be denied or abridged by the United States or any state on account of color, race, or previous servitude. Article 1, Section 2 describes how the House of Representatives is made up and who votes for these representatives. Electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. Each state must allow anyone who can legally vote in their state elections also vote for U.S. representatives. But if the voting requirements in states are not consistent throughout all of the states, the results of the elections will not be consistent with the views of the people. Lowering the voting age to 18, whether it be a local, state, or federal election, is necessary to ensure a consistent manner in which elections are held across the nation. The right to vote is the foundation of our nation's democratic government. 18, you are legally allowed to enter a binding contract, discontinue school, but you can also be punished for criminal behavior. In fact, an 18-year-old can be convicted of a crime that he cannot change. When our nation was in the first stages of creating an independent government, many requirements were inherited from past practices. By age 18, it was considered time to end schooling and continue life as an adult.
There are differences in the age at which a person can marry in the various states. There are differences in terms of ages related to criminal prosecutions in the various states. Why does it need to be consistent in terms of the age of voting in the various states? We have differences in those areas that I've just elaborated on. Why does it need to be consistent in terms of voting age across the state? Well, what does that accomplish?
Again, as was stated before, this does bring up the fact that when you vote for U.S. representatives, any member of a state who is able to vote for that state can vote. But if the states have different voting ages, then certain states will have an advantage for voting for U.S. representatives.
Thank you.
For example, a recently graduated 18-year-old African-American female has been watching the news in regards to an abortion law in the process of significantly limiting the rights of abortion in her state. Should she not be allowed to vote because of her age? In fact, at the federal level, she is allowed to vote for a constitutional amendment, but she cannot participate in the state's debate. This is discriminatory in every way, and because of her age, she may be forced to use voter fraud to impact the decision of the state. Additionally, the economic factor of the states cannot be ignored. Inconsistent voting ages would require separate ballots for 18 and 21-year-olds, which unnecessarily increases cost to financially strapped states. Further, residence and literacy requirements would result in additional and heightened discrimination, as my co-counsel Madison Mayo will now explain in greater detail.
Thank you.
Literacy tests are inherently discriminatory because not every individual receives the same education. Oregon's contention that a person must read well to qualify to vote is meritless. In this day and age, there are countless opportunities to learn about elections without the capability to read. For example, you may listen to the radio or watch the news. It is simply not reasonable that the direct consequence of the inability to pass a literacy test results in the disqualification to vote, which is a fundamental right in the United States.
Ms. Mayo,
America.
Las Vegas. Ms. Mayo, a question from Las Vegas, and that is that with respect to literacy and voting, people frequently vote for more than just candidates for an office. Oftentimes there are very complicated issues such as amending state constitutions or referendums on enacted laws for the various states, and isn't a higher level of education needed to be able to vote on those very complicated issues?
No, because politicians should be equally distributing their information and not restricting their information to one news source. America is built on the foundation of inclusion, not exclusion. There is no compelling state interest in the use of literacy tests. Literacy tests highlight a national dilemma, the dilemma that to this date, not everyone has the same opportunity to receive quality education. Because of this, literacy tests have a long history of discrimination against not only African Americans, but minorities. As the state of Arizona pointed out, a literacy test would impose a burden on elderly Native Americans because of this country's history, did not receive the same education as an elderly white. The Equal Protection Clause prohibits states from denying any persons within its jurisdictions the equal protection of the laws. Necessitating literacy tests discriminate against a person for their qualification to read or write, which is against the Equal Protection Clause. What constitutes for literacy tests is problematic. Literacy tests in nature are subjective. What one person may believe to be acceptable may not be acceptable to another. Previously, the United States Supreme Court has held that under Section 5 of the 14th Amendment, a state may not deny any individual the right to vote in any federal, state, or local election because of any test or device, including literacy tests. Moreover, residency requirements are also unconstitutional under the 14th Amendment. No voter can be denied the right to cast his ballot in a federal election because he or she has not lived in a state long enough to meet residency requirements. Implementing residency requirements discriminate against people who exercise their constitutional right to migrate. For example, say you are a Caucasian male student who just reached the age of 18 years old in the time of a voting year. If you reside in Nevada and decided to relocate to Utah State University, you are required to live in Utah for 12 continuous months to be a resident. If the court were to adopt Oregon's argument,
A question from Las Vegas, and that is that doesn't the 10th Amendment provide that the states have the right to govern the time, place, and manner, and part of governing the manner is making sure that the people who are voting in your election in your state are residents of your state and have an interest in what happens in your state. Isn't this inherently a duty of the states and not something that should be imposed on them by the U.S. government?
but Congress has the right to overrule the state's decision because Congress has the right to rule the time, place, or manner in this regards to manner. If the court were to adopt Oregon's argument, then the student would not be able to vote until he resided in Utah for 12 continuous months, meaning he would miss the very first election he could otherwise legally vote in. States are prohibited from abridging the voting privileges of citizens, which is enforced in the 14th Amendment. Furthermore, the court should take into consideration the migrant and seasonal workers that migrate across the country. This nation is built upon a migrant commerce, including businesses selling products cross-country, traveling healthcare professionals, nurses, emergency room doctors, or farmers and ranchers with land in different states. The examples are immeasurable. People of several states should swing or swim together, and in the long run, prosperity and salvation are in union and not division.
Do we have any questions, any other questions in Las Vegas for Ms. Mayo or for Ms. Gilboy? Any questions in Las Vegas? Any questions in any of the other locations for council?
One from Carson City. You
you.
stated that 18-year-olds can be sentenced as an adult, as well as 16-year-olds and up. 16-year-olds going to have a sentence, and then they could be trialed as an adult. So are we also saying that 16-year-olds can vote?
No, it depends, of course, on the crime. If you went out and killed 5 people and you're a 16-year-old, you obviously knew somewhat of what you were doing, so you deserve to be punished that way. 18 is, you're considered an adult, so the crimes that you commit, you're going to be punished as an adult. That is for everyone.
Any other questions for council? Justice Theta, I hear no other questions for council.
We have a question in the courtroom.
Are you arguing for federal requirements or states as well? How do state elections affect federal elections? Don't state elections only pertain to their state legislatures?
I'm not sure if that question could be heard. I'm going to walk back and ask if you would repeat that question.
Are you arguing for federal election requirements or states as well? How do state elections affect federal elections? Don't state elections only pertain to the state legislatures?
Do we have an answer from either of our parties in this case?
Will you please restate the question one more time?
Sure.
You guys can hear me, right? Okay, so are you arguing for federal election requirements or states as well? How do state elections affect federal elections? Don't state elections only pertain to their state legislatures?
It depends. For now, with the voting, we are arguing for federal and for state, because with the state elections, if you have different ages voting, then those individuals with the qualifications requisite might not be allowed to vote for the federal. So this is going to affect the states, which in will return will affect the federal, which will be the benefit of our country.
Thank you very much. I believe that we can move into our deliberations at this point. Judge Sturman, I would ask you act as the chief in the deliberations there. Oh, wait.
Thank you.
Perhaps we have another
All right.
question. Oh, wait, we have one more question that's coming in. Hold on.
Another question, thank you.
Before you begin your deliberations. We have several more questions.
Okay, so this is for Lowry, correct? Okay. You say that 18-year-olds can be tried for a crime, enter into a binding contract, and enter into the military. Therefore, they are affected by the vote of the nation and should be allowed the right to vote. But wouldn't that also mean that those under the age of 18 be affected by the vote as well? If so, why should we limit the age to 18?
And before you answer, for our audiences who may be watching either podcast, who may be in other remote areas, some of these questions are coming in actually from other students, as I believe I'm seeing. They're coming in on the electronic process. So we're happy to say that we are reaching, as we hope, throughout the state. The answer to that question, and they may want it repeated because there was a couple of questions there. I'm not sure which side wants to answer this question, but one more time.
Okay, so my question is, you say that that 18-year-olds can be tried for a crime, enter into a binding contract, and enter into the military. Therefore, they are affected by the vote of the nation and should be allowed the right to vote. But wouldn't that also mean that those under the age of 18 be affected by the vote as well? If so, why should we limit the age to 18?
No, I do not feel that those under the age of 18 should be affected and allowed to vote, because those who are under 18 are still in school. They are still in government classes. They are still learning what is going on. They're also not allowed to enter a binding contract without their parents' consent. They are still living in the house, and therefore they do not have the right to vote.
Question from Carson City. What about those emancipated 18-year-olds that actually go to school, but they're 18 at the age of their senior year? Are you still stating that that rule still follows?
I feel that they do have the right to vote because they are 18. They are still going to be punished as a criminal. They still have the right to vote.
But you said that they needed their parents' permission. What happens if they don't have their parents' permission? Like I said, they're emancipated.
When you're emancipated, that is a personal choice.
"18-year-olds receive intensive training before being sent to war, so they are prepared. We do not prepare voters except as an auxiliary effect of education, which is not consistent. Thus, literacy testing makes sense, and the issue of going to war and voting are completely separate. Do you disagree?"
I feel that those who are prepared to go to war at 18, we will go back to this time period and say that a lot of them were drafted. They did not have a choice. And you are being prepped from voting from when you start understanding what's going on. You are going to government classes, you are seeing things on the news. I do feel that you are prepping for voting.
We have also offered an opportunity for there to be some response to some of these questions from our student lawyers here in Carson City. Is there a response you'd like to offer to this question? Or preceding questions as well?
Yes, we would like to respond to one of the questions. I'm gonna go for it.
Yeah. Okay. Can we have the respondent or the student before ask a question again? Sorry. It's like,
yes. I'm going to repeat the question.
So you say that 18-year-olds can be tried for a crime, enter into a binding contract, and enter into the military. Therefore, they are affected by the nation's vote and should be allowed the right to vote. But wouldn't that also mean that those under the age of 18 be affected by the vote as well? If so, should we limit the age to 18?
We definitely agree that people under the age of 18 can be affected by what occurs in our legislatures. For instance, many students under the age of 18 who are still students in high school, say, have jobs and do pay taxes. Therefore, those people are unquestionably affected. But we have to understand that a line must be drawn somewhere. We can't lower the voting age to 5 years old. And that line is going to be drawn based on things such as brain research and when we feel that people are ready to vote and capable of understanding what they're doing.
We're going to allow one more question, and then we're going to have our Las Vegas bench deliberate. One more question.
Why is the minimal age for joining the military at age 18, even though what has been stated earlier, that 21-year-olds have higher levels of thinking? Wouldn't soldiers that have higher levels of thinking be able to make better decisions on the theater of war?
Do we have a response? From Winnemucca?
Okay. Can you please restate the question one more time? Don't talk.
Why is the minimal age for joining the military at age 18, even though what has been stated earlier is that 21-year-olds have a higher level of thinking that would benefit our nation's military in the theater of war? Soldiers that have a higher level of thinking can make better and more thought-out decisions whilst serving our military.
Everyone is trained to go into the military. Everyone is trained the same. Now, for some people, you may have a higher thinking level at age 21, but I do not feel that this applies to every single citizen who is going into war.
And here in Carson City, do our attorneys wish to respond?
Well, I think what we need to recognize is that we know there are outliers to these brain studies, but we have to look at general trends when we're making the decisions that will affect our nation so significantly.
Thank you very much. Chief Justice Sturman, would you begin your deliberative process?
Yes, thank you, Justice Seda. First, I'd like to ask our student justices to introduce themselves and tell us how close they are to having this issue be relevant to them. Are they 18 or looking at being 18 in time to vote this year? Thank you.
My name is Erica Jefferson, and I am actually at the age of 18 right now to where I am going to vote. As you guys, Oregon stated earlier how a lot of students aren't, at the age of 18, aren't mentally ready for this type of, they're not ready to make these type of decisions for our state. But I believe that, we've gone through, with the government or history to learn about what's best for us, for our state. And I think that if at the age of 18 you have these people who are going into the military who are ready mentally to go in, I think that people at the age of 18 should be ready to vote. So I rule in favor of Mitchell
Thank you. Okay, and we'll have hear from our other justice.
My name is Dulce Valencia, and I am also 18, and if given the opportunity, I would definitely vote. Now, in regards to this, there is an inconsistency with what we are allowing. We're allowing 18-year-olds to go to war, to get married, and to drop out of school, but yet we're not giving them the right to vote. So I also agree that this inconsistency must be addressed, and Congress does have the power to set the age for voting at 18 on federal elections, but that it should be a state issue when deciding on local elections.
Thank you, Dulce. Justice Denton.
Well, I referred earlier to, in one of my questions, to the fact that we're a federal system. We have 50 states. We've often heard the term 50 sovereign states. But we're 50 states of the United States of America. We're a cohesive nation, the basic premises of which should extend across the land, in my opinion. We're a democracy. We pride ourselves on that. And I question, how can we send young people, even illiterate people, off to war and not permit them to participate in the democracy that we pride ourselves on being? I mean, I remember back into my childhood, civics classes, hearing the term no taxation without representation, and then I wonder, how can we lose life without representation? So from my standpoint, I think we look at this as, sure, we're 50 states, sure, we're supposedly 50 sovereign states, but there are these basic things that go across the land, and one of those is the right to vote.
Thank you, Justice Denton. One of our colleagues asked the question, really, wasn't this just politically motivated? It was just an attempt to, by one party, to try to block a president from another party by increasing the voting pool. And that's frequently thrown around as whenever there's any challenge to voting, is that it's just being politically motivated. But the Constitution makes it very clear that the states are to govern the time, place, and manner of voting within their states. I do not believe that the age a person votes is part of time, place, and manner. I think that the age that a person votes at is a national concern, and that it should be uniform nationally, because otherwise you would have inconsistency between the states. Eventually, all the states got to the point where the sort of the age that everybody settled on as the age of contracting, the age of marriage, the age of dropping out of school was 18, and they all reached that eventually just through the independent acts. But I think that voting was something that required a national stance on, because as of this date, only 2 states had actually allowed those that are under the age of 18 to vote. So I think that it was incumbent on Congress to take this action and to take this stance for all of us, because I remember as a child watching this go on, and the argument being that we're sending people to war to fight and die, and yet we're not letting them vote, and that's just inherently unfair. And I think that Congress acted appropriately in changing the voting age. I know that Justice Cherry asked, why was this something that you could do through congressional action as opposed to the people amending the Constitution of the United States, such as they did to allow voting based, to prohibit people from limiting voting based on gender or race. Why would we then not change the Constitution to allow voting by age? Well, respectfully, I don't think that age was ever in the Constitution. I think it was just appropriate, therefore, for Congress to be the ones to act. So I would also vote to uphold Congress's action to support the government in this.
And I would like to clarify, too, that we're not sitting in review of any lower court on this. This case has been filed directly in the Supreme Court, and my vote is that the challenge against the Voting Rights Amendments of 1970 be denied.
And we have two issues in this, and our council were very good to argue it, although the thing that is most concerned to all of us is age of voting. A very important part of this act, and that is under challenge, and we'll hear a little bit more about it in a moment, are the other kinds of things you can do to limit or to influence voting. And those are literacy tests and residency requirements. So I don't know, Council, our fellow justices, if you have any thoughts about what Congress taking this action to do away with literacy tests and and residency requirements, and how that impacted voting rights, and whether that was appropriate for Congress to have done.
Well, I agree that literacy tests are just a form to limit voting to minorities. So I believe that Congress, we should not place these literacy tests, because every citizen has a right to vote, and we should not limit that to whether you can read or not. As for the resident requirements, I'm kind of divided on that. I think that those should stay in place, because people should meet certain residency requirements when they're voting for local elections and things that affect that state. Because if they just moved from another state, and the issues in those two states might be different, so they should be allowed to be residents of that state for a certain time before they can actually vote on issues that impact that state.
Thank you.
I agree with Dulce as well. I believe with the residential requirements, it wouldn't be fair for someone who just moved from, say, like New York, who moved down to like Florida and only stayed there for a month to try to say what's best for their state. So I would say that residential requirements would be best.
A minimum period of residency in the state.
Correct.
All right, but you agree that literacy tests were just a thinly veiled attempt to exclude minorities from the right to vote?
Yes.
Thank you. Justice Denton. Not that I have an opinion.
No, I've already indicated I would deny the challenge on all bases that's been made by the state.
Thank you. Justice Sada, I think you have uniformity among our justices that we would deny the challenge to the Voting Rights Act amendment.
Thank you very much, Madam Justice. We will move into our next case.
Justice Sadie, could I add just one point on that last case? I thought briefly, Judge Montero gave a historical perspective on the previous one. And if I take 1 minute, I'm the second oldest justice. Justice Cherry's the oldest, so we go back and remember this. But in the 1972 election, contrary to what Justice Higgins said, and I know I voted, it was the first election I voted in because I had turned 18 before that election, but it was thought that all the young people would vote against President Nixon because of his support of the Vietnam War, but actually President Nixon won 49 of the 50 states in 1972. It was the largest victory ever in a presidential, at that time. It was matched by Ronald Reagan in 1984, but President Nixon had to resign less than 2 years later because of the Watergate scandal, and he's the only president that ever had to resign from the office of the presidency. But with that, sorry for interjecting that, but I thought it was
point of personal privilege for the oldest judge to say something also.
Absolutely.
Another historical perspective is that when they lowered the voting age, guess what? Guess who could serve on juries then? 18-year-olds. And in Clark County, I was a criminal defense attorney at that time. And because they lowered the age, I was involved in the first case where an 18-year-old actually sat on a jury in the state of Nevada. So that's a historical note. And yes, there were dinosaurs walking in the streets when that 18-year-old served.
As you can see, the progression of our cases today brings us pretty historically up to date, if you will, with respect to certain voting matters. And I think the historical perspective from a dinosaur or otherwise is pretty important because we all lived it. I, too, have to join in that generation and acknowledge that Vietnam and this entire process was pretty important to me at the time. I was just about ready to vote at that time. So thank you. Any further historical input from our justices? Wow. With that in mind, we will move into the next case, which is Shelby County versus Holder. Are the parties ready to proceed?
Can we get down?
Representing Shelby County are students from Canyon Springs High School in North Las Vegas. Representing Attorney General Eric Holder are students from Elko High School in Elko. Our presiding bench are here in Carson City consists of 8 individuals. So I am going to simply only introduce the Chief Justice Mark Gibbons, who will control and ultimately convene the deliberations in this case. As our judges ask questions on this case, if you would please identify yourself by name and school, we would appreciate that. The next case, Shelby County versus Holder. Are the parties ready to proceed?
Justice Seda?
We're ready in Las Vegas, Your Honor.
Thank you.
Justice Seda, point of order.
Yes?
I think we're having some issues with audio. If those who are not speaking could mute their microphones because we're hearing a lot of audio feedback. If that's possible, that would greatly assist us.
Thank you very much. We've got our IT people right here. We're going to take care of that. Let us know if you need us to correct anything else. Are the parties ready to proceed?
It sounds much better now. Thank you.
Thank you. On behalf of the appellant, Canyon Springs, are you ready to proceed?
Yes.
Yes, Your Honor.
You may do so.
Chief Justice, and may it please the court. The Civil Rights Act of 1965 was a landmark piece of legislation enacted by Congress which justifiably prevented voter discrimination. The court itself previously stated that such a law is constitutional, and today we're not here to deliberate that. Under Section 5, states deemed to have potential for discrimination by Section 4B are not able to change their voting laws until the Attorney General or the United States District Court of Columbia determined that the change did not have a discriminatory effect. Previously, in 1970, 1975, and 1982, when Congress renewed the special provisions, it deliberated with experts. Recently, though, in 2006, there was no deliberation and was reenacted again for more than 20 years. Now, the question here presented today is whether or not Congress's decision in 2006 to reauthorize Section 5 of the Voting Rights Act was, under the pre-existing coverage formula of Section 4B, exceeded its authority under the 14th and 15th Amendment, thus violating the 10th Amendment and Article 4. Today, I, John Ito, and my co-counsel Julie Thompson and Ryan Samano are here to address this very question. Both the District and U.S. Court of Appeals held that Congress did not exceed its power. However, we stand here before the court confidently saying that the issues that were relevant 40 years ago no longer pertain to voting today, and voters are faced with new discriminatory challenges. The challenges we face today are different. Thus, we must apply a new rule and a new pre-clearance formula to be applied to the states. And now, my co-counsel, Mr. Ryan Samano, will present the first argument.
May it please the court. Firstly, we will assert that Section 4 and 5 of the Voting Rights Act are no longer relevant today, and that Congress has had time to change them. In the case of Northwest Austin v. Holder, Congress was given time to change the Voting Rights Act. The Supreme Court stated in the majority opinion that the act raised serious constitutional concerns, and the court gave Congress several not-so-subtle hints to fix the law. The Supreme Court went even as far as not answering one of the questions presented in the Northwest Austin case. The court chose to avoid the question of whether or not the extension of the Voting Rights Act was a valid use of congressional power. The Supreme Court decided to leave the issue to Congress, and well, Congress has had time, it's had its time to change the act. And therefore, we have brought this issue once more to the court. Now, when the Voting Rights Act was passed in 1965, Section 4 and 5 were only supposed to be temporary provisions. They were only supposed to be in effect for 5 years. And the court held that the Voting Rights Act was constitutional in the case of South Carolina v. Kassenbach, due to the act being a legitimate response to the insidious and pervasive evil which had denied blacks the right to vote since the 15th Amendment's adoption in 1870. So the court upheld the Voting Rights Act because there were states in the United States of America who were not respecting the 15th Amendment. The
Question from Carson City. Justice Michael Cherry, University City High School, University of Missouri, and Washington University Law School. My question is, wasn't the Voting Rights Act to punish the South for their discrimination against African Americans, et cetera? And now I hear the word New South. Because we have the New South, do we need this type of monitoring of these southern states?
We do not need this monitoring. We are going to prove that the formula used to govern these states in order for them to get pre-clearance to pass voting laws is outdated.
And in addressing
Should we
your
look
first
at
question-
maybe some northern states or even some states in the West where there may be discrimination and still have them be able to have their voting processes monitored rather than the New South?
Yes, when the Voting Rights Act was first passed, it was meant to address blatant and obvious discrimination, and today it is discrimination has evolved, and we now have a second generation form of discrimination, and so we're going to prove this, and we're going to bring up several examples of other states that are not in the South, that are not covered by the coverage formula, who are discriminating against their voters. So, when the court upheld South Carolina v. Kassenbach, they felt that the circumstances in the country gave a legitimate excuse for them to uphold the law, and so since then the South has changed, and we acknowledge that discrimination existed back in 1965, but today today is a different case. The Voting Rights Act, was reauthorized by Congress in 1970 for 5 years. And it was then reauthorized again in 1975 for 7 more years. And then again in 1982 for 25 more years. And most recently, it was reauthorized in 2006 for 25 more years. And to prove that the South has changed, in the Northwest Austin case, in covered jurisdictions, voting registration was approaching parity, and blatantly discriminatory laws were becoming very rare. Also, minorities were now holding office at an unprecedented level. Now, this data was only collected a few years ago, so it is growing. The court has recognized that certain parts of the South have made progress, and voter registration in minorities and voter turnout is almost equal. The court has also recognized that Section 5 pre-clearance is based on data that is 35 years old. Section 5 is too broad when it is applied to the states, and it is an overreach of Congress's enforcement powers. This was explained in Northwest v. Austin. It allows Congress too much control over the states' elections only when they're covered. The Voting Rights Act was meant only to affect states who had a history of discrimination. And as shown previously, the South has changed, and disenfranchisement laws have moved away from the South. There are other states which are not under the covered jurisdiction.
Justice Chair, I have a question in Las Vegas. May I ask it, please?
Certainly.
Justice Gibbons?
Yes.
May I ask a question? Thank you, sorry. Doesn't that just prove the need for these pre-clearance requirements, that they have worked, and therefore they should remain in place? Because that's what has allowed these significant improvements to occur. And if we do away with them, we're going to go right back to where we were before.
They have worked for the discrimination that they were meant to address. But as I've previously stated, discrimination has evolved, and now we're seeing these really subtle laws that subtly discriminate against voters in other states, such as Ohio and Michigan. And these two states, they're not in the covered jurisdiction of Section 4 and 5. And so this is causing disenfranchisement of many minorities. And with that, this being said, I will pass it to my co-counsel, Julie Thompson, for the second argument.
So the Constitution requires that all laws implemented within the United States be equal throughout the states. Now, the exception to this rule has been that states who have a history of discrimination must go to the Justice Department before changing their voting laws. This is an undue burden on those states because they have extra hoops to jump through when they're not the worst offenders. This act is not being fairly implemented. Now that these states have improved their policies against discrimination, they have increased voter registration and turnout at polls. The formula in Section 4 of the Voter Rights Act states that it applies to states that had tests and devices as prerequisites to voting and had low voter registration and turnout in the 1960s and early 1970s. But we are living in a new century. All the while, states like Ohio and Michigan are making laws worse than anything these 9 states have come up with in the last 20 years. In Ohio, just before the primaries of 2012, John Husted, the Ohio Secretary of State, said that the suburban counties of Butler and Warren counties would be extending their voting hours. Now, this sounds like a great idea. However, the same would not be happening in Hamilton County. Hamilton County contains the large city of Cincinnati, which happens to be largely Democratic. In fact, the extended hours in Hamilton County were eliminated. The same happened in Cleveland, Columbus, and Akron, Ohio. The percentage of blacks in Cincinnati and Cleveland are 45% and 53% respectively. Butler County is 8% black, and Warren County is 3.5% black. Now, these counties were most likely to vote for Mitt Romney, while counties with bigger cities were more likely to vote for President Obama. This kind of discrimination is called second-generation discrimination. It is classified as being subtle and pervasive, while first-generation discrimination is classified as being blatant and obvious. Now, to us, the appellates, the discrimination in these states is clear, yet these counties don't have to go to the Justice Department to change their voting laws. The same goes for counties in Michigan. In these counties, people must show their IDs at the polls. People are not allowed to vote early, and they have to put in an absentee ballot if they cannot make it to the polls on election days. Now, these absentee ballots may or may not be accepted. If they can't register to vote on election day either, which greatly limits their ability to vote in the first place. And Michigan asked the Department of Homeland Security for immigration status data. They use this data to remove suspected non-citizens from their voter rolls. All of this is happening while Texas doesn't even require its citizens to show ID polls. Studies have concluded that 11% of eligible voters don't have government-issued IDs, and this percentage is even higher in seniors, minorities, people with disabilities, low-income voters, and students. Many of these groups don't have the necessary paperwork to get these IDs, and to get that paperwork can cost time and money, neither of which people can waste. This is why ID laws are so effective in preventing low-income voters and minorities from voting. People should not have to pay extra to exercise their right to vote. In this day and age, we can't afford to marginalize these counties. We can't judge them on their past when they have been working so hard to improve the status quo for minorities in the states. All we are asking is that the act be changed to apply to the states that also practice discrimination. And I would like to call upon my co-counsel, John Ito, to sum up our arguments.
The Voting Rights Act of 1965 was passed on the grounds of the Equal Protection Clause, and justifiably so. But it would be a grave mistake to believe that we can have equal protection without applying a law that protects against discrimination to states that have it. The current Voting Rights Act pre-clearance only applies to certain states in the South, Arizona, and Texas. But like my counsel said before, Ohio has been passing discriminatory laws, and we do not question the constitutionality of the Voting Rights Act. Simply, we want it to be applied equally to all the states. And until Congress can do so, we strongly ask you to see that the reestablishment of this act to be unconstitutional. Thank you.
Are there questions from the court of the appellants here in Carson City?
Any questions from our judges in Carson City? Apparently not.
Very well. The respondents in Elko, are you ready to proceed?
We are, Your Honor.
You may do so.
All right. Your Honors, striking down Section 4B and 5 would be a disastrous mistake. Section 5 of the Voting Rights Act is the biggest tool that the federal government has in its tool belt for fighting discrimination. It requires that districts, counties, or states with a history of serious violations of citizens' rights to vote are subject to preclearance. Preclearance is the pre-approval of changes to the voting laws in the state subject. Section 4B goes hand in hand with Section 5, as it is the formula that provides Section 5B with all of the states that it must look over. Removing Section 4B is like chopping off the leg of the Voting Rights Act, because without it, the act cannot stand. While there has been a large decrease in voter discrimination, it does not mean that it has disappeared entirely. Voter discrimination has moved from extremely visible policies to laws and provisions that quietly undermine the minority vote. Just because there is progress, it does not mean that you ought to remove the bill that has led to that progress. Just because a country is at a time of peace, they should not disarm their military forces. Getting rid of protections just because they are working is counterproductive and wrong. The Voting Rights Act is a crucial piece of federal protection of the fundamental right to vote. Every person in the United States ought to be able to vote for whom they choose and how they choose, regardless of the minority or majority opinion. To restrict this right in any way is to enact an egregious violation of the people's fundamental rights. If states or districts are the ones committing this violation, then it is the federal government's job to reprimand them. Your Honors, you may hear today that the formula outlined in Section 4B is outdated and therefore cannot be effective. The appellant will say that because the formula was written in 1965, that it can no longer be applied to modern-day America. If this was the case, then, by that logic, the Constitution would no longer be applicable to modern-day America, seeing as it was written in 1787. Your Honors, the date on the name tag does not change the fact that this act has done and will continue to do wonders for civil rights. And it should continue to play its part, since discriminatory policies are still being sent to the Attorney General for approval. For example, in 2004, Waller County, Texas, attempted to reduce early voting at polling stations near a historically black university and threatened to prosecute students for illegal voting after 2 black students announced their intent to run for office. Pleasant Grove, Alabama, enacted an at-large election in majority black neighborhoods. At-large elections have been shown to dilute the minority vote and participate in the never-ending cycle of discrimination. Shelby County, Alabama, the appellant in this case, have used similar tactics in their own districts. Many states, including the ones under preclearance, have implemented voter ID laws that place undue restrictions on the voting populace and unfairly discriminate against minority voters. And in many states, voter suppression continues to exist. In the Virginia 2006 elections, minority and Democratic voters received fraudulent phone calls saying that their vote would lead to their arrest. There continues to this day to be a constant struggle to uphold everyone's right to vote. 20% of all African Americans in Virginia are disenfranchised, and 1 in 3 African Americans in Florida, Kentucky, and Virginia are disenfranchised. Hours of early voting, a time where there is a mainly minority voter turnout, are constantly being attacked and shrunk down to an unacceptable size. Even though we have come a long way from the Jim Crow laws, there are still many problems that need to be solved, and getting rid of preclearance and the mechanism that makes it possible is a step backwards in times. You, the court, must be certain that your actions do not undo all of the positive progress that we have made. Another claim you may hear today, Your Honors, is that the preclearance is a burden on areas that are not discriminatory. However, preclearance is a necessary burden with a fairly simple solution. In Section 4A of the Voting Rights Act, the law states that areas under preclearance have the ability to opt out or bail out of preclearance. It requires that the states have had a clean 5-year history of no discriminatory policies and have actively attempted to combat racism and all its underlying forces. The states have also had an increase in minority voting in that state. If a state or district believes that they ought not to be under preclearance any longer, then they can petition to the Attorney General or to the judge panel to remove them from the preclearance list. There is no reason for states or districts to think that the preclearance list is set in stone, because not only can states bail out of it, they can also bail in. Section 3C of the Voting Rights Act states that the Attorney General has the ability to add areas to preclearance that violate Section 5. And I would like to thank the appellant for pointing out all the places where 3C needs to be enacted so that 4B and 5 can expand to have those districts in there as well. Bailing out and bailing in have both been proven effective. Nearly 200 jurisdictions have successfully bailed out of preclearance since the updated requirements in 1984. And several jurisdictions have been bailed into preclearance, including the states of New Mexico and Arkansas. Obviously, the claim that Section 4B is static and continues to apply to areas that have long solved their discriminatory policies is faulty. The Voting Rights Act was enacted by a majority vote by Congress. Since then, majority after majority have reaffirmed this act, continuing the approval of preclearance. Since the United States is a representative democracy, the members in Congress represent the people that vote for them. Therefore, the majority of Americans have and continue to approve of the Voting Rights Act.
Well, counsel, I've got a question. When does it end? I mean, we finally got over Reconstruction in the South. You know, the Civil War happened well over 140, 150 years ago. And this act was supposed to last for 5 years. It was supposed to expire in 1970. And Congress has just repeatedly pushed it down the road. Last time for 25 years, they extended the act with what was arguably little to no deliberation and no looking at the current actual statistics. So at some point, where does this extraordinary use of federal power to remedy what was a horrible situation, but it has to end sometime. It just can't be continuously. So when does it end?
It ends as soon as states respect the right of people to vote. There's been many states that have continued to attempt to enact discriminatory policies towards the minorities in their states. And as soon as states
but the flip side of that coin is when somebody wants to change their ballot form or move early voting up a day or move the date of their primary, every other state in the union and every other locality is free to do that. But if you're one of these affected states, some bureaucrat at the Department of Justice gets to decide whether you get to print your ballots on bigger or smaller paper. At some point, Go ahead.
Well, the law applies to tests or devices that are proven to be discriminatory against minorities. And so these laws and devices in these states, counties, or jurisdictions are presented to either the Attorney General or a 3-panel judge of district court judges in a District of Columbia. And so it's not that every single law that these states are going to enact are going to be struck down. It's only the ones that are proven to be discriminatory because these states have a history of violations of the right to vote. Like I said with 3C, if these states, or 4A, sorry, if these states have proven that for the past 5 years they have not enacted any or sent any discriminatory policies to the 3-judge panel or the Attorney General, and they have had an increase in minority voting, so those two combined, they can opt out of preclearance and continue on with their voting laws without preclearance. But the reason why preclearance still exists on these states is because the laws that they are presenting to the Attorney General continue to be discriminatory. That's why they're still under preclearance. And as soon as they come out of that discriminatory system, they can move from preclearance. So it's not.
Well, in other words, you're
like
saying that there's no end date. This could be continuing for the next 100 years.
The council and I believe that the fundamental right to vote should be guaranteed to everyone. And if district, states, or jurisdictions restrict that right, then there needs to be action because that is taking away a fundamental human right of the citizens of the United States. And so if that continues and continues to be a problem, then yes, it will. The 5 and 4B will continue because our citizens deserve to have their rights respected by their own states.
This is a question from Las Vegas, if I may be permitted to ask it. Justice Gibbons?
Yes.
My understanding of what you're saying is that when does it end is a matter of policy that has been established by Congress. Congress has determined that it doesn't end yet because, having looked at it, it's determined to extend it, correct?
Yes.
That's what you're saying. It's a policy issue that's been set by Congress, and that this court, the court should not be second-guessing Congress on when it ends.
I believe so, yes, because of what it's been doing, the fact that it's been so beneficial for the past 50 years that it's been in, and it continues to prevent discrimination, that it should continue, and that the fact that we are arguing against such an amazing tool for preventing discrimination, it shouldn't happen.
I believe we had a question in Carson City.
Yes, if I may.
Yes, you may do so.
Thank you. So are you saying that this law that they implemented from 1970 hasn't had any type of progression into what it is now, even though that in 2008 we had the biggest minority voter turnout? So why is it still fair to the northern states to not have these prerequisites that they have to do before they change up anything, while the southern states have to because of something that they've done from 170 years ago?
Well, while there's definitely been progression, what we need to see is that it's less blatant than it used to be, but it certainly still occurs. Disenfranchisement runs rampant through the states that are under jurisdiction.
So if we have, I have a question, Chief.
Proceed.
So if we have voter ID in Los Angeles, but you can't have, what's going to happen to voter ID in rural Georgia? You going to be able to have voter ID in rural Georgia? Or maybe you have to show a driver's
Voter ID
license or identification?
Voter ID laws in two separate Supreme or court cases in both Arkansas and Wisconsin, the ID laws have both been determined to be unconstitutional because it puts unfair burdens on the voting populace.
Those Supreme Court
And
cases?
so voter ID laws.
United States Supreme Court
was-
cases?
It was a federal judge in Wisconsin as well as in Arkansas.
Yeah, so we've got a long way to go between the Court of Appeals and also the Supreme Court of the United States on voter ID. But what's your opinion if there's a voter ID law that's held valid in California or Arizona or Montana? Can you have voter ID in rural Georgia, rural Tennessee? Or is the bureaucrat, as Judge Higgins said, going to say, nope, can't have that voter ID because you're in the South and we're still fighting the Civil War 150 years after it's over?
If the laws in the other areas are proven to be discriminatory, then under the bail-in aspect that I was discussing, they should be placed under preclearance as well. But if the voter IDs in the rural areas in the South are considered to be non-discriminatory, then they will be able to be enacted. That's the preclearance, is just determining whether the laws are discriminating against the minority or if they aren't. If they aren't, then they can enact them.
I have another question from the
Yes, you may proceed.
Is it fair that only some southern states to be affected when really all states could be discriminatory at some point of time?
That's why the bail-in bailout is a great part of this law, is because this protection exists, and so this aspect of the bill, the bail-in and bail-out, can allow states that are discriminatory to bail in and then non-discriminatory to bail out. So what happens is that this law is extremely fair because it gives states a chance to prove themselves, but it also allows states that are violating our fundamental right to vote to be bailed in. So it's fair based on the laws that those states are passing.
Question from Carson
Or
City.
attempting to send the Attorney General.
Go ahead, proceed.
Thank you. So you don't see any type of discrimination with the fact that all the other states get to do this while some southern states don't? Isn't that a form of some type of discrimination?
It appears that way on the surface, that it's discriminatory, because it's some states and it's not. But what we need to see here is that this law is protecting the citizens in those states. The reason why those states are under preclearance is because they were violating their citizens' fundamental right to vote. That's why those states are under that. If the states had not violated their citizens' fundamental rights to vote, then they would not be under preclearance. And that's why this law is fair and is constitutional, because it's protecting the citizens in the states where it needs it, and it's not affecting the states where they don't need it. So it's only applying to the states that have had the problem.
But this was a temporary law. Why does it keep on reiterating even though it was a temporary law?
Well, it's a temporary law. It was a temporary law, but it's so effective that they felt the need that because discrimination continued, that this law needed to continually be upheld because it's helping. It's solving issues. And like we said, discrimination, there's been progression. It's not definitely as bad as it used to be, but this law continues to be a shield against discrimination. And so as long as it's actually benefiting, then it should continue to be upheld.
But you stated that you didn't believe that there was any positive coming from this. You stated that yourselves.
No, there's absolutely 100% positive impacts coming from this law. It's reducing voter discrimination in all of these states. And the reason why voter discrimination has reduced is because of this law. May I continue with my arguments?
I think, Counsel, your time is up. However, we're going to leave it open to if there's additional questions. First of all, I'll start in Carson City. If any of our justices in Carson City have any additional questions.
I have a question.
You may proceed.
Earlier, I believe you said that taking away part of this voting act would basically get rid of the progress that we've made, but you aren't really giving a chance for those states to show that even without the act, they can still make progress.
Well, the problem is these states are still trying to introduce laws to the Attorney General that are discriminatory, and then the act is the protection against this.
Okay, any other questions from Carson City? If not, let's go to Elko. Judge Simons is there. Judge, do you have any questions?
No, I do not. Thank you.
Okay, and why don't we go to Winnemucca with our Judge Montero and his colleagues in Winnemucca?
I think the attorneys have done a wonderful job today. No questions from Winnemucca.
Thank you. And we'll go to Las Vegas. Chief Justice Sturman and Judge Denton and your colleagues in Las Vegas. Do you have any additional questions?
Any questions in Las Vegas? We have no questions in Las Vegas. Thank you, Justice Thierry.
Okay, thank you very much. Then, Justice Sada, do we have any questions electronically have been submitted?
Have we received additional electronic questions? Mr. Sommermeyer? I'm assuming silence is no further questions electronically. It is time then for us to begin deliberations. The bench here in Carson City is a rather large bench, but I would like everyone to have an opportunity to participate in the decision making. So if you would, Chief, you may begin your deliberations.
Thank you, Justice Sada. And what we'd like to do here in Carson City is give our student justices the first opportunity to vote. So I'll go through all the students, and then the three remaining judges do this all the time. So we'd like to get some input from the students first, and we'll go ahead and vote. So I'll start on my left here with our first student judge here. First of all, if each student judge would state your name and your high school, and then go ahead and tell us your analysis of the case and how you would vote on this one.
Hello, my name is Judge Jennifer Nito Duvetter from Virginia City High School, and I feel that great progress has been made by the southern states from over 100 years before, and that I feel that this law is no longer valid. Because if we never give them the chance to show that they have improved, then how are we ever going to trust them?
So you would vote in favor of the appeal filed by Shelby County then?
Yes.
Thank you. Okay, let's go to our next student judge.
My name is Aaron Hacklerite. I'm just Aaron Hacklerite, and I'm from Virginia City High School. And I believe that in over 100 years of change, I don't know how to say this, that over 100 years, great many things have changed, and it is time for this law to be undone. So I vote in support of Shelby County.
Okay, thank you very much. Okay, let's go to our next student. And sir, if you'd go ahead and state your name and your school and how you would analyze this case.
My name is Matthew Roberts from Virginia City High School. I would vote in favor of Holder. Yes, there has been major changes, but if there are still laws that are being brought up that show discriminatory actions, these laws should still stay in place until those are gone, because who's to say that as soon as they're gone, the southern states won't relapse into discriminatory behavior.
Great, thank you very much. Yes, ma'am. Would you go ahead and introduce yourself and state your analysis of the case?
I'm Hannah Aragini from Damani Ranch High School, and I am in vote for Shelby County because even though this act has done wonders for the progress of the states, I think it's time to give the states a chance to show that they can continue to make progress without this law.
Thank you. And sir, again, would you reintroduce yourself and state how you would analyze the case?
Brandon McQueen from Damani Ranch High School. When this law came into effect, it was a great thing for segregation and everything else. But like I said before, in the election of 2008, we had the largest voter turnout in our minority cases. So you could already see that it's outdated. And the Constitution is still living document. And it was supposed to be a temporary 5-year law. And it's been going on since 1970, before we were even born. I vote in Shelby County.
Great, thank you very much. So far, just to recap, we have 4 votes in favor of Shelby County, 1 vote in favor of Eric Holder, our Attorney General. So we'll now go to the elected judges and justices here. We'll start with Justice Kevin Higgins. And Justice Higgins, how would you vote on this one?
Well, to start with, I'll introduce myself, Kevin Higgins, the Sparks Justice Court. Sparks High for a little while, then I finally finished at Reed, so there's a story there somewhere. Okay. It's interesting. I think that the extraordinary changes have been made. I think the statistics cited in the majority opinion in the case show that the voter registration has significantly changed in the last 50 years. 50 years ago, 69% of the white voters in Mississippi were registered to vote, but only 6.7% of the black voters. Today, 72% of the white voters are registered and 76% of the black voters. There's actually higher voter registration in some of these states by minorities than there are by the former white majority. And I think these constitutional violations should be handled the same way as any other constitutional violation. So if a case is brought that the state can't handle, and there's no indication here that the state Supreme Courts, which are now made up of men and women and minorities, there's no indication the state courts couldn't handle these situations. And if they can't, the federal courts are still available, and it should be handled just like any other violation of any other constitutional right without this extraordinary intervention. So I'd vote to affirm the opinion of the United States Supreme Court.
So you would vote in favor of?
Shelby County.
Okay, thank you. Okay, and Justice Cherry.
Well, Matt, I supported you when you went to Alabama with your project, and I'm one that feels that you shouldn't stand alone on this, and I'm going to agree with you. So we at least have 2 votes. I'm used to being in this. Justice Sade and I a lot of times find ourselves, and Justice Gibbons too, for that matter. When you become a Supreme Court justice, you got to learn how to count to 4. And in this case, you had to really count to 5 since there's 8 of us. But Matt, I agree with you. I just don't want to take any chances with this. You look at the electoral college as far as the South is concerned, and they're still very much towards the Republicans. They may have many African American and minority office holders, but usually it's not in the Senate and it's not in the House of Representatives. So until that happens, Matt, I'm with you, and I'll vote for Eric Holder.
Okay. Thank you very much. My vote is, first of all, I want to commend both the student advocates on behalf of both schools, like that. I think you did an excellent job here, made excellent arguments on behalf of your respective clients. I am, though, persuaded by the students from Elko High School. I do agree with what both attorneys from Elko High School stated. I think in this situation here, even though the Voting Rights Act may be antiquated as far as areas in the South for the reasons my colleagues have stated, it's still within the discretion of the United States Congress. If they wish to extend it under our federal supremacy clause there, it gives them, the federal government does have the final say on this issue. And for the reasons set forth by my 2 colleagues that voted in favor of Mr. Holder, I would also vote in favor of Mr. Holder. So the final vote, Justice Seda, I think is 5-3. And as you find out with appellate courts, it's a little different than a trial court. It's all about who gets the majority, as Justice Cherry pointed out. So in this case, the final vote is in favor of Shelby County.
Thank you very much. Before I proceed, I want to be certain that each of our jurisdictions across the state have an opportunity to add anything that they would like to add to today's Law Day presentation. Is there anyone who wishes to make a statement or ask a question of any of our advocates or any of our student judges? And in fairness to Mr. Sommermeyer, I know I called out asking whether or not you had any electronic questions that you wanted us to consider. I was advised that you were doing an interview with local media. And so thank you for bringing to the attention of our media Law Day Live. That's as important as what we are doing here in each of the courtrooms. Is there anything from our electronic jurisdictions, if you will, Mr. Sommermeyer, that you would like us to consider?
His answer was no.
Thank you. Let me start today by congratulating every single student advocate, every single student judge. And I can say unequivocally, I am proud to know that when you all take over the reins of our country, we are in very good hands. You have shown today that you understand the process, that you were able to reach back into the late 1800s when women were not allowed the right to vote, and you were able to argue with great passion as to why women should be given that vote, or why not, as the case may have been for that state of Missouri that made an interesting decision. But having said that, if you've watched the progression of our cases here today, we are in the current time now. The Shelby County case was just argued, as I mentioned, last term in the February 2013 term before the United States Supreme Court. It is important not only that you recognize what came before, but that you continue to understand the legal process and to protect the rights that have been given to you. It was not that long ago that more than 50% of us, by gender, females, were not allowed to vote. It is not that long ago that people between the ages of 18 and 21 were denied certain very important rights. And clearly, it is not so long ago, as about a year and a half ago, that people were still having to be carefully monitored with respect to how they provided access to voting. As the ABA theme today emphasizes, every vote matters. You must not only be diligent to protect your legal rights, but you must get out and vote. We are in an election cycle. What this is all about is the precious right that each individual in our country ultimately will have to elect the people who make the laws, who interpret the laws, and who bring the laws to you in your everyday life. So the work that you've done here today, any one of you could represent me, and I suspect that our real judges would agree with that. And I hope that each of our judges would have a comment to make for our student advocates as well as our student judges. Chief Justice Gibbons.
Well, thank you, Justice Seda. And again, I was just overwhelmed by the quality of the advocacy by our student judges today. I know you're in high school. I urge you all to finish your 4 years of college, and I think each and every one of you that spoke today would be an outstanding lawyer, and I think are almost ready to argue before the Nevada Supreme Court. But before you can do that, you have to graduate from college, and you have to go to law school, and if you go quick, you can get through law school in 2.5 years. So it's not that long, like that, if you go through summer schools and all. So you could be a law graduate. I became an attorney when I was 23 because I was able to get through school a little bit quicker. So it's seems like a long time, but you can do it, and I'd urge you all to consider that career or other careers. But go finish your schooling up, finish your college, and proceed accordingly. Mhm.
And your law school alma mater, Chief, was?
Mine was Loyola University of Los Angeles. I have to concede it's not rated as high as Justice Cherry's law school, Washington University in St. Louis, but it's still a good school. And now we have, back then we didn't have a law school in Nevada. Now we do at Boyd Law School at UNLV. So we have our own public law school, which you're all eligible to go to. Mhm.
Judge Montero, comments regarding our student advocates, student judges, and the students who have supported the preparation for Law Day 2014.
Yes, Justice Seda, thank you very much. I just can't say enough great things about the young people that have been involved in our program here at Lowry. This group of students also are very active in our teen court program, so I get an opportunity to watch them perform in the courtroom before Law Day Live, and so it's been very rewarding to watch them here today again. I want to thank a couple of people real quick. I have a lot of people at the Lowry High School that deserve some recognition. Mrs. Hill, who is still with us today, one of our teachers who is a mentor, the advisor for the teen court program. And Richard Haas and Massey Mayo, our two attorney mentors, are here, and they've really coached our young people throughout the year, and I thank them as well. Many other people, but especially to them, they're still here with me today. And thank you to my colleagues on the bench and to the attorneys who argued the case today.
Judge Sturman in Las Vegas, comments for our student advocates, student judges, or the students who are in our courtrooms?
Thank you, Justice Seda. I think Judge Denton and I would like to follow up on something that Justice Gibbons mentioned, I think Justice Cherry mentioned, and that is that along with the very important right to vote, at the age of 18, you also have the right to be on a jury trial. And since we're trial judges, we encourage everybody to exercise your right to serve on a jury when called. We would like to thank here in Las Vegas our representatives from the state bars, legal education department who are present, as well as our friends from Project Real who came today. And talking to our student justices, they mentioned their involvement in We the People, a wonderful program that we encourage everybody to be involved in for civics education. And again, thank you all to everybody who participated. It was really inspiring.
Judge Denton, I have failed to ask for alumni. First, Judge Montero, your law school alma mater is?
Washburn University in Topeka, Kansas.
And Judge Sturman, your law school?
Arizona State University, a Tier 1 law school. Sandra Day O'Connor's College of Law.
And Judge Denton, comments that you would like to make to your student advocates,
Yes,
your
I
student
would,
judges, or those who are participating locally?
I would like to thank everybody for participating in this. I hope that the students will go away from this recognizing that we have an outstanding judicial system, an outstanding legal profession in this country, and people can come into court and make their points and respond to questions. It's a deliberative process. It's an academic process that's involved, and I know that the students have taken a lot of time in preparing, in presenting their arguments, and again, I hope they come away with it from this with an appreciation for what it is that we have in this country, in our judiciary, in the legal profession we have. I'm a graduate of Georgetown University Law Center in Washington, D.C. All right.
Judge Simon?
Thank you so very much. I just wanted to thank our wonderful students that we have here in Elko that put in a lot of time in getting ready for this. Amelia Lamp, who's a junior at Elko High School, Jackson Paris, a sophomore at Elko High School, and Sophia Blair, a senior at Elko High School. This is pretty stressful to have all these eyes, not only watching them in the various courtrooms, but on the internet and the like. We also appreciate the instructors that have worked with them. Scott Guthrie at Elko High School, and they have a student teacher chaperone here with them today, Chip Briggs, who's also here supporting them. And also they had one of our local deputy district attorneys gave some of our student advocates some advice and help with their presentation. And we appreciate the help of Rob Lowe, and he's here in the courtroom as well, supporting them, and we appreciate that. I'm a proud graduate of Nevada's own law school, the William S. Boyd School of Law, and happy to say so.
Judge Higgins.
Thank you. I'm also a graduate of Georgetown University Law Center, although I'm proud to say I paid off my student loans almost 2 years ago now. So perhaps Judge Denton paid his loans off sooner than that. I think today this is a shining example of why civics education is so important. We're discussing issues today that we've been arguing about as a country since before our founding. Who gets to make decisions? Who gets to vote? Is it the big states or the small states that get to decide things? Who in those states gets to decide things? And it's a discussion and an argument we've been having for over 200 years now. And I think the student judges and the advocates have also learned that when you're in these roles, you don't always get to make the decision based on what you would personally like to do, that you're bound by the law. And I think Judge Paquette in Winnemucca found out that she voted one way on a case based on the law and the history at the time that directly would have adversely affected her on her right to vote. So it's always interesting. I get asked questions about how can you be somebody can be a defense attorney? How can you defend guilty people all the time? Well, it's the system we have here that everybody gets an advocate that is zealous and works as hard as they can, whether they like the person or agree with them. And sometimes as judges, we make decisions that we personally wouldn't agree with if that was the way we made decisions, but we don't. And so that's why civics education is so important. And we get asked questions, how did the judge make a decision? I think we have an insight into some of that, how it's bound down. I was very impressed with all the advocates. And I'm sorry I'm the only Sparks High person here, but maybe next year.
Justice Cherry.
Well, thank you, Justice Seda. I was, of course, very much impressed with the advocates, and every time they argued, I got swayed, whether it be the appellants or the respondents, I was swayed, so great job. The student judges, I appreciate their deliberations and their questions, very, very impressive. And the students in the audience, too. What a great job everybody did. And this is a highlight for me as a Supreme Court justice to be able to participate in this. And Justice Sada and I go back a long way. We were on the district court bench together from 1999 till 2006, and then we came up here in 2007 and now become Northern Nevadans, which we really appreciate. And even though I went to school in Missouri at Washington University Law School, the smartest move I ever made was coming to Nevada in 1970. But there's one other thing I want to say as the senior justice here at an age, dog years. Just to say that you never seem to amaze me on what you've accomplished with this law day. I know you've been had national recognition in 2011 and 2012 and 13 and probably this year. And what you do is just magnificent for the community, for the entire state of Nevada, especially the educational system. You know, people make fun of our educational system. Well, I'm impressed. I'm very impressed with everybody that participated today, and I'm proud to be a Nevadan. And I'm proud to be a justice with my friend Justice Sada. Congratulations, Nancy. A great job again.
We have a couple, we have also Justice of the Peace, Eileen Harrington. You were instrumental in helping our VC kids. Are there comments that you would like to make?
Well, what I'd like to say is, well, I probably don't need this, but I just want to thank all the students. You really impressed everybody, and this is the first of many years. Mr. Shropshire, he is Everett Shropshire. Would you please stand up? He is the government teacher, and thank you, Mr. Shropshire, and Deputy District Attorney Ann Langer, who has worked with you tirelessly throughout the past several weeks, and I'm just really impressed by all of you, and we're going to be doing this every year, okay? I have the easy part, okay? You guys get to do it, okay? Thank you.
And I think, Justice Cherry, you did a great segue, and it wasn't even written in our script. We have now mentioned a few of our teachers, but there's a courtroom full of students here. I understand there are courtrooms and auditoriums full of students throughout the state. They wouldn't be where they are today without our teachers. And we also have here in Carson City, we have Mr. Chad Sawyer from DeMonte Ranch. I know, And Mr. Sawyer got brought into this, sort of dragged into it a little bit late in the process this year. But thank you for being a part of our Law Day Live today. Mr. Shropshire, obviously, thank you so much for being a part of our process. Dr. Grillo, I'm assuming that you are in Las Vegas? Apparently so. I also want to recognize here in our courtroom, we have David O'Mara, we have Mr. Connor, Jeffrey Connor, attorney mentors, along with the previously mentioned Ann Langer, who helped our VC students. I get to do something tomorrow that is a huge honor that I owe thanks to all of you. I will be in Las Vegas tomorrow at a gathering of the American Bar Association, and on behalf of our state bar, I will be able to accept an award for law-related education. And that means that because of all of you, our state is once again going to be recognized for exactly what your teachers, your attorney mentors are doing. And for that, I thank you for giving me that opportunity. I would also like to give credit and great thank yous to our department, Nevada Department of Education, Project REAL, the Washoe County School District, the Clark County School District, and Jim Rogers, one of the media moguls in the state of Nevada, has also prepared for us and broadcast PSAs throughout the state. And that is a huge help for us to get our message out. A couple of people who always make up the heart and soul of Law Day Live. Michael Sommermeyer and Myrna Bird in Las Vegas. Would you please stand and be recognized? One more mentor thank you. My law clerk, Owen Mooney, who is standing behind me, not only helped mentor the teams up here in northern Nevada, but he was cast today in the role of clerk of the court. And I might note he did a fine job. Thank you, Owen Mooney. And finally, my backup, the Judicial Chambers Assistant Extraordinaire, Vicki Roberts, if you would please stand and be recognized for the support that you give me. And in case you didn't recognize the last name, she is, I hope, a very proud mom of one of your student judges, Matthew Roberts, here today. So once again, I am really thrilled and honored to make closing remarks by saying thank you for another amazing Law Day Live. I hope that we will continue in this endeavor for many, many years to come. And for the students who did not get to participate today, either in Las Vegas or Elko, Winnemucca, or Las Vegas, you were so important to getting your colleagues where they were today. Thank you for being a part of Law Day Live. And Mr. Chief Justice, I believe we are complete. We can adjourn.
Okay. Mr. Clark, can we adjourn the court? Okay.